ready to start when you are. Can she hear me? Madam Magistrate, are you there? She doesn't hear me, I don't think. Yeah, it's on.
Can you hear us fine? I think you might be muted.
No, we can't hear you. Still, no, we can't hear. Are you muted? Is she muted on your end, Jacob? Jacob's working on it. Sorry for the technical difficulties. Still working on it, Jacob?
All right, let's try it again. Can you hear me okay?
Yes.
Now we can hear you.
Oh, awesome. Perfect. All right, you ready to get started?
Yes?
All right. This time for real, third time. Good morning. Welcome to today's court enforcement hearing. I'm Myrna Bel-Rashid. I'm going to be your special magistrate today. First off, I want to say I hope that everybody present fared well during the hurricane last year, and that you're on the path to recovery. I know Fort Myers beach was.
It went out again. Hold on.
Hold on.
The sound went out again real quick. I don't think she hears us, maybe. So I'm assuming you found yes.
All right, it looks like.
There we go.
There we go. Back up again. Okay.
We got it.
Alrighty, let's do this again. Everybody who's here will be providing testimony. Please stand up and raise your right hand for the taking of the oath. Do you swear from the testimony you're about to provide is the truth, the whole truth, and nothing but the truth? Okay. With that, I'm going to ask the city to please call our first case for the morning.
Good morning. We have continued our first three cases. The first one was Prasad Properties, the second one also Prasad Properties, and third Prasad Properties. Our first case will be Nature View Court LLC. It is a stop work order without permit remodel, 313-317 Nature View Court.
And I have received the case files for all the cases here today. 2. Alrighty, let me hear from the city. From the town.
Thank you, Madam Mayor. Special Magistrate John Heron, Town Attorney, on behalf of the town. At this point in time, we would bring forward Officer Bill Stout. Officer Stout, you've been sworn in?
Yes, sir.
Okay. Could you please state your name for the record?
William Stout.
And are you employed by the town of Fort Myers Beach?
Yes, I am.
In what capacity?
As a code compliance officer.
And in that capacity, is it your responsibility to enforce the city's codes and regulations as adopted by the by the town council?
Yes, sir.
Are you familiar with the property that is located at 313-317 Nature View Court?
Yes, I am.
Can you please tell the special magistrate? For the record, special magistrate, we're here solely on imposition of fines. So
Okay.
So, Officer Stout, has this matter come before the special magistrate once before?
Yes, sir.
And is it your understanding that as the result of that was the order, issuance of an order by the special magistrate for the property owner to bring the property into compliance?
That's correct. Yes, there is.
Can you refresh everyone's memory what the violation was and what the order, the special magistrate's order was as it relates to compliance?
Without permit, lower level build out into a habitable space, a living space. We had the case come to hearing in front of the magistrate for an order. The order was ordered on the 18th day of March, 2021. And at that time, the magistrate indicated that the respondent is ordered to correct the violation by coming into compliance by however means necessary. The space is to remain unoccupied.
And to refresh the special magistrate's memory, the nature of the violation, it was the build out of the space below the base flood elevation?
Yes, sir.
Under the town's code, is a permit for such improvements authorized by the town code?
Yes, it is required,
No.
authorized.
So, can you have livable space below the base flood elevation?
Not to my knowledge, no.
Okay. Is that what the violation was, that you observed that there was livable space in the downstairs area?
Yes,
Okay. And evidence of that was entered into the record?
yes.
Okay. Have you had an opportunity to reinspect the property?
I personally have not.
Who has?
I do not believe that the town has had, any town representative has not had permission to inspect the interior.
Okay, so as of today's date, the town staff has been denied access to the property for purposes of verification and compliance with the special magistrate's order.
That is correct.
And as a result, is it deemed to be a non-compliance?
Yes, it is.
Nothing further at this time, Madam Special Magistrate? Yes.
Okay. Sir, please come up to the podium, state your name and relationship to the case, please.
Good morning, Dwayne Dickerson. I'm an attorney with the law firm Danae Misquin Backman, offices at 14 Southeast 4th Street in Boca Raton, Florida, and I am the attorney on behalf of the respondent, which is Nature's View Court, LLC.
All right, and what would you like to say in reference to the failure to comply with my order from last year?
Well, first of all, Madam Special Magistrate, I want to start with the town's Land Development Code, Section 2-424, entitled, I'd like to present a certificate of completion that was provided to the town's building official on April the 26th, 2022, right? And as you may know, we had a private provider who provided the services for pulling the permit and preparing the work. So if you look at the private provider statute, which is Florida statute section 553.791, and is specifically titled Alternative Plans Review and Inspection, but industry speaking, it's the private provider statute. So there's a section here, which is section 553.79112, which says, upon completion of all required inspections, the private provider shall prepare a certificate of compliance on a form acceptable to the local building official, summarizing the inspections performed and including a written representation under oath that the stated inspections have been performed and that to the best of the private provider's knowledge and belief, the building construction inspection complies with the above plans, with the approved plans and the applicable codes. And that's in part. And then the next section, which is 553.79113, states that no more than 2 business days after receipt of a request for a certificate of occupancy or certificate of completion, and the applicant's presentation of a certificate of completion and approval of all government approvals required by law, the local building official shall, which as you know is must, issue the certificate of occupancy or certificate of completion, or provide a notice to the applicant identifying the specific deficiencies as well as the specific code chapters and sections. So your state statute and so state law states that once we submit this certificate of compliance to the town, they have 2 business days to either issue our certificate of completion or issue a notice of deficiency. So I'd like to present the certificate of completion, if I may.
Did you provide a copy to council?
Yes, ma'am. I'm provide a copy to
Okay,
council
perfect.
and to Madam Clerk.
All right. Obviously, doing it by Zoom, I don't have the opportunity to look at that certificate of completion. So let me hear from, once you complete your argument, we'll go ahead and hear from the city attorney to hear what he has to say in regards to that certificate of completion.
Yes, ma'am. And with all due respect to the town, this is state law. It's based in the state statute, and there's no discretion or jurisdiction that the town can supersede this state statute. They have to, and this is the Florida statute in the version that was applicable at the time that we submitted our certificate of completion. So they had 2 business days to either issue the certificate of completion or issue a notice of deficiency, and specifically the chapters and the sections that we're deficient. Now, it goes on to say that if the local building official does not provide notice of the deficiencies within the prescribed 2-day period, the request for a certificate of occupancy or certificate of completion shall, which in the laws must, be deemed granted, and the certificate of occupancy or certificate of completion shall be issued by the local building official on the next business day. So if we've never received a notice of deficiency, so by state law, it's our position that the certificate of completion was granted. So not only do we have a building permit, which I believe satisfies the violation and complies the violation, but we further did the work. And I would like to cross-examine Mr. Stout when it's appropriate, Madam Special Magistrate. But we did the work. We called inspections, and we followed the state statute, which has clear provisions on inspections and notifying the town. We did all of that. They had every right to come there. It was represented to me, and I can have my co-counsel testify to that, but it was represented to me that the town did come out on certain inspections. So there was never anything hidden by the town. We followed the letter of the state statute in utilizing our private provider to secure the permits, to perform the inspections, to submit the certificate of completion, and to comply this property. And we've done all of those things. So when it's appropriate, I'd like to reserve a few moments in rebuttal, and I would like to cross-examine Mr. Stout.
Sure, I get some clarifications because I think I heard 2 conflicting things. Was the certificate of completion actually issued?
The town, it is my understanding that the town never responded to our notification of certificate of completion. So my legal position is that by state statute, it automatically was issued,
Okay.
whether
so
they represent it or not. I'm sorry?
It's your argument based on legal, but you don't have a physical document that says certificate of completion signed. Okay.
The
I
town
just wanted
did
to
not.
clarify.
That's
not
a-
making a ruling as to either
Sure.
or. I just wanted to make sure that there's no actual document that I'm missing. Okay. Let me hear from counsel for the city.
Special Magistrate, rather than, I'd like to reserve the right to respond and allow counsel to cross-examine Officer Stout first, so we can then, respond
All right.
to any of those statements as well.
No problem in having him cross-examining the inspector. I just wanted to make sure if you had a response to the legal portion
Yes,
of the argument,
and
if you want to represent it now. But it sounds like you want to do it all in one.
We do
Sorry.
have argument to be made in opposition to the statements, the argument put forth by opposing counsel.
All right, so let's go ahead and at the town's request, he's going to go ahead and waive at this time the argument. He'll do it afterwards. Let's go ahead and allow you to go ahead and cross-examine the inspector. You may call him.
Thank you. Inspector Stout? Yeah, I'm sorry, I don't know if you can see, Madam Special Magistrate, but there's some other conversations going on, so I'd like to have that on the record if possible.
All right?
Thank you. Good morning, Officer Stout. So my,
Bill, come forward.
yeah.
All right.
So my first question is, yes, sir.
Well, let him ask you questions as to your testimony, and if necessary, we'll supplement the record with Officer
Correct.
Lee, and he'll have the right to cross-examine him as well.
Right.
So, please.
Correct.
Yes, thank you. Just for the record, as you know, Madam Special Magistrate, this
All
hearing
right, so
is based...
first of all, there's only one mic, so you have to hear it, because I can barely hear Inspector Stout when he's a little bit
Oh.
away from the mic, so you guys got to get a little
That's
closer.
all right. Well, I showered this morning, so I'll let him get I'll let him get in front of the mic when he speaks, if that's okay.
Okay, great, thank you.
Okay, thank you. So, Officer Stout, first of all, thank you for your hard work. This is my first time coming to the town, and wow, the news doesn't do it justice. So, I know you had a lot of work on your hands. I would like to ask the Counselor, town attorney asked you if there was a way that the ground floor could be habitable space. And your answer was no. And I hope I'm going to give you an opportunity to rehabilitate that answer and asking it again, because I believe, as you are aware, there are properties that are grandfathered that have had habitable space downstairs, and that they can continue to have habitable space and even remodel that habitable space as long as they don't go above the 50% rule of the assessed value of the property. Is that not an option, to have a grandfathered habitable space which is at or below the base flood elevation?
I think that's more of a legal question, but I'm going to see if
Either one, but Madam Special Manager, his legal counsel asked him this question and he answered it for the record. So,
No.
so I'm happy to hear both of them answer, but it's my legal position that there is a grandfathered vesting right to have habitable space below the base flood elevation if you're grandfathered, and you can remodel that space as long as you don't exceed the 50% threshold. And I will also state for the record that it's my understanding that at the first hearing, this matter came up, and the town's position was that there's no way we would get a permit because of this very issue, and that position was overruled, and the permit was issued. So I don't think it's appropriate to go back and try to reevaluate that position. It was already settled based on the overruled position that town had and the permit being issued, that you can have habitable space below the base flood elevation as long as you meet the requirements of the vested, the grandfathered status, or you're at or below the 50% threshold with the remodel. And so I hope he would like to rehabilitate the record with his response.
Madam Clerk, if I may, before Officer Stout answers this question, I would object to the question and the request as it's been framed and explained by counsel for the following reason. That issue was, as he just stated, addressed and very vigorously presented to the special magistrate at the original hearing on the notice of violation. That was a significant amount of time was taken up during the course of that hearing on whether or not the existing improvements up to that point were grandfathered or not. And the property owner, through counsel at the time, which was different than current counsel here today, was unable to provide any evidence that any of the improvements in question predated the National Flood Insurance Program, and your Honor's ruling was that all of the improvements downstairs either had to come into compliance one way or another as it related to
Correct.
the issue of being a habitable space below base flood elevation. So I just want to.
And I do remember the case. I do remember the case quite well. I can see a picture of the property itself, and I do remember the arguments that were presented at the time and what my ruling was.
So
like I said, I think a lot of what he has is legal argument, but I think he also has a valid point in asking the inspector
Sure.
regarding the inconsistency, or at least the apparent inconsistency. So I'm going to allow him to go ahead and ask Inspector Stout if he knows how that gets resolved.
Inspector Stout, can you please answer the question?
It is my belief that that property does not,
No, I'm sorry. I'm just saying, generally speaking, the question was asked of you, it wasn't specific to our property, it was, can a property have habitable space below a base flood elevation? Your answer was no.
No.
I'm hoping that you...
Objection. His
I
answer-
don't
his answer
think
was
that's
not
what he said.
no.
I think it was in particular for this
To this-
property. I think the
precisely.
statement was in regards to this
Okay.
property.
Okay,
If
so let me
counsel
be,
wants to ask the
let me
question
be
in
more
general.
specific then. Is there a way that a property can have habitable space below a base flood elevation? As long as they're grandfathered or they remodel at or less than the 50% threshold?
it is my belief there are ways that you can have habitable space below flood elevation, but I do not know if it would apply to this property.
And it's my understanding that those same arguments were made by the town at the special magistrate hearing, and subsequent to that, those arguments were overruled and a permit was issued to do remodel downstairs.
Objection. Form of the question and the characterization that was overruled. No one's overruled.
I'll allow it
A permit was
to the
issued.
extent on how, if he knows how the contradiction between, because I remember the argument. The argument was, and I agreed with it, was that if it had been legally done in the first place, within the time frames that the grandfathering would apply, then yes. But for this particular property, since the work was done without permits, they don't get the benefit of that grandfathering. But I'm also seeing where council's going in regards to, while that was the argument and that was the basis of my ruling, in terms of the getting, basically, and I remember making it this way, basically resolve the issue regarding the permit, whether that was because you're able to get the permit or because you have to remove everything and bring it back to its original condition, thereby resolving the violation. We do have evidence that we have a permit that was in fact issued for the renovations. Now, it is possible that it might have been a limited type of permit, not to
Fair.
that it wasn't blessing the entirety of the remodel, maybe a portion, but I want to hear from the inspector how was a permit ended up getting issued when we had previously argued, and I found for the town to that basis in regards to they're not entitled to the grandfathering because the work was done without permits.
We'll address that on redirect.
But I have an open question, and I believe I'm entitled to cross-examine the officer, and I would like him to answer that question.
Correct, that's
All right,
what I
thank you.
said, that I want to hear from him again if he knows.
Thank you.
How did the building department end up issuing a building permit?
Right.
That we have, that is an evidence that we have, when we had previously discussed, and I had found for the town in that argument,
Right.
in regards to the grandfathering cannot be had.
Yes, ma'am.
Because it was originally not grandfathered.
Yes, ma'am. And to foreshadow.
And I think the argument goes to waiver. I think that's
Exactly.
where counsel said.
And to foreshadow my next points, not only did the permit get issued, but there were inspections that were had. They were invited to all the
Hold
inspections.
on, counsel, hold on. You're adding more questions.
All right,
Let's go
we'll
ahead
let
and
him
hear.
answer that one first.
So, okay, so let's go ahead and hear first from the inspector. If you know, how does that, how when the town made the argument that it wouldn't be able to get a permit because it wouldn't be grandfathered, a permit did end up getting issued? Again, if you know.
I do not have that in-depth knowledge on that. To my knowledge, the permit was issued for storage.
I'm sorry, the permit
Madam
was
President,
issued?
He said the permit, to his knowledge, the permit was issued for storage. But if
Okay.
you look at the face, with all due respect, we can't speculate. We're dealing with facts and competent, substantial evidence. And if you look at the face of the permit, it states
Well-
that, I'm sorry?
Madam Mayor?
I was going to say, there might be, the question was directed at this particular inspector. Just
Yeah.
because he doesn't have knowledge doesn't mean that there might be another witness that might have that knowledge. Because this is the witness you called. He may
That's
or may not
fair.
have that
That's
information.
fair,
There might be
and-
somebody else
and
the
I
city
s-
might want, the town might want to call to go ahead and provide you with that information.
That's right, and of course, I would like to stand on the four corners of the permit itself that says what it's for. So I don't think we need to speculate or read into it. The permit says what it's for, and the inspections follow that, and the plans that were submitted and everything else, and then the certificate of completion, so.
But now, hold on, but are you going to ask him the question or are you going to testify?
No, I think,
Okay.
so he said not to, he's not aware, okay.
Okay.
Okay. So my next question is, are you aware that the certificate of completion was submitted to the building official on April the 26th of 2022?
I do not have a record of that.
Okay. And are you aware of the requirements of Florida statute 553.791 when it comes to alternative plans review and inspections, otherwise known as the private provider statute? He's aware or not?
Yeah, okay.
Are you aware or no?
No, sir.
Okay. So you wouldn't know if the town followed the requirements of the state law, which is that statute, which requires them to either issue the certificate of completion within 2 days of that notice or to issue a notice of deficiencies within 2
Objection.
days.
I think he answered that question already. Move on.
About that? Okay. All right. I reserve any rebuttal based on the other inspector's testimony with Mr. Stout, please. But that's all my questions for right now.
All right, counsel?
Yeah, redirect, Your Honor.
Absolutely.
Officer Stout, Mr. Dickerson has entered into the record as evidence, as document to support his argument, a permit number 210808. Have you had a chance to take a look at that?
Yes, I have.
Based upon your knowledge, fully understanding and that you are a code enforcement officer, do you have any familiarity with the town's general permitting procedures?
Yes, I do.
Okay. Would it be correct to say that this piece of paper, this permit, is the end process of the permit application and review process?
I don't believe it is.
Okay. What comes, very briefly, to get to the issuance of this permit, what needs to be submitted, if you're familiar?
The required documents for the permit need to be reviewed by staff, and then upon review, they will issue the permit. My understanding on this particular permit, it is still waiting for resubmittal of some documents.
And is the permit application in the file, and has it been provided to the special magistrate?
Yes, it has.
Again, to the best of your knowledge, does any of the information that was submitted in the permit application backup indicate that the permit was to build out habitable space below flood elevation?
Not to my knowledge.
Nothing further.
If I may cross-examine?
And then we do have legal argument to make as well.
All right, so, okay, so What I have here, I'm trying to see if I can actually see the actual permit. Because for the property owner, do you actually have a copy of the physical permit, or is everything just the permit application?
No,
Because my
we-
package only has the actual permit application that provides a permit number, but not the actual issuance of that permit.
Madam Special Magistrate, we actually have the issued permit from Fort Myers Beach, which tells the job location and the description of work and the date. It says date issued, so I believe it's sufficient to say this is the issued date because it has a date issued on the face of the permit document.
And Special Magistrate, that document has been provided to us and a copy to the clerk. It is part of the record.
Okay.
And it is, you know, the town does not disagree that it is a permit.
Now, the application does say interior remodel. Don't have a copy of the permit. What is the work description in the permit itself, not the application?
If I may, Madam Special Magistrate, the permit document has the job location, which is the property in question, the property owner, who is the respondent, the name of the contractor, Specialty Building Services, and it has their general contractor number. It identifies the property by strap number, which is the Lee County Property Appraiser's assigned number, permit type residential, subtype remodel, and then description of
There you go.
work,
Okay.
interior remodel.
Okay.
Nothing more.
And Madam Special
Now-
Magistrate, I'm sorry.
Let me go ahead and I have a copy of the plan that was submitted as part of the application permit. Unfortunately, the lettering inside is a little blurry, so I can't see. And what I'm trying to decipher from that permit plan is the inspector made a statement regarding it being for storage as opposed to a living space. And one thing that I immediately see here in the plan review, even though I can't read the specifics of what the types, the letters say, I don't see a bathroom, which leads me to believe that it is what was approved was not intended to be habitable space.
Madam Special Clerk, I would say the language of the permit tracks the language of the violation. The violation says remodel.
That wasn't my
and the permit says
question.
remodel.
That wasn't my
But I
question.
but that was
That wasn't my
earlier.
question.
But that was earlier, but the plans. So your question, it was always habitable space. Before my client purchased it, it was habitable space. And any work that he did was referenced in the permit documents and the plans that were approved pursuant to the permit, and then that are consistent with the certificate of completion that was issued, which I believe the town is stating, and if not, I'd like to ask, did they provide a notice of deficiency? So
Well, the certificate of completion was never issued. That's your argument
it was
that it was, but
once
there's no physical
once we issued
document,
it to
right?
them. Yes, ma'am, that's right. Once we issued the request pursuant to the state statute for a certificate of completion, it's my understanding that the town never responded, and then therefore in violation of the state statutes.
And I understand the argument, but I just want to make sure that there is no confusion on the record that there is no physical paper issued by the city doing that certificate of occupancy. I understand your argument that once it was sent in and it was not executed or responded to, that by default they waived it and it's issued. I get the argument, but right now I'm going to make sure that everybody's clear that there's no physical document that said certificate of occupancy of certificate of completion has been issued.
That's right. You are correct. Or in the alternative, pursuant to the state statute, a notice of deficiencies and the chapters and sections of the code that we are deficient. So if there was an issue, the town had a legal obligation to let us know there was an issue, and we never received that. So, you know, we're confident that the work that was done is consistent with the requirements of the code and the permits and what we've submitted. And if it wasn't, the town had a legal obligation to let us know, and they have not.
Now, I have a question for you, counsel.
Sure.
The documents that I have do have an attempt for an inspection on April 20th of 2022 with a notation in April 27, 2022 that says that they were not provided access to the building to ensure that the flood vents are installed in compliance with the interior partitions walls are as constructed with FEMA compliant flood resistant material. To your knowledge, was the city allowed to enter to go ahead and confirm that what was done is compliant with what FEMA required?
That's a very good point. As you know, this hearing that we're here today for was supposed to take place originally supposed to take place in May of 2021. So this is, you know, right at a year later, when we're 2 years later now, but when you're talking about those comments, that was when we issued the certificate of completion. So I believe if you read through them, the dates don't match, and it's like when we issued the certificate of completion on April 26th of 2022, then all of a sudden there's all these notes in the file about notice and everything else. But to answer your question, it is our position that we've notified the town of all of the required inspections, and we've made the property available for them to participate in inspections if they deem appropriate. They don't have to by the state statute, but we have to notice them, which we did. So I don't believe, and it's been represented to me that there's never been a time where we've hidden the space from them and not allowed them to inspect.
Is your position that sending the certificate of completion that wasn't signed your attempt at providing notice for them to inspect?
No.
Is that your argument?
My argument is that the certificate of completion triggers statute 553.791.
No. You just stated that the town was notified.
Right.
To go ahead and that the owner was willing to provide access. I have a document from the city saying they didn't give me access. I understand your argument that was much later after you had submitted that attempt to send the certificate of completion.
Right.
And it wasn't responded to. But my question to you is, prior to sending that certificate of completion, in your attempt to trigger the statute, whether there was a request to the town, hey, listen, guys, I'm done. Come over and do the final inspection.
Right. Well, two things. One, it is my understanding that we notified the city, or the town rather, of all inspections that they were required to be notified of, and we allowed them the access that they wanted pursuant to those inspections. So I've never, it's been vehemently represented to me that the town was notified and they were given any and all opportunities to inspect pursuant to that notification. But the last thing I'll say is, if the town took the position that we did something inappropriate, they were by law required to notify us. That would be a deficiency.
Well, I think you're putting the cart ahead of the horse.
Well, we can pause there.
Because if I follow your argument, I can go ahead and get a permit to build a house, put a couple of masonry blocks in, call the inspection out, and they never go out. I send them a certificate of completion. All of a sudden, I have a brand new house just because I put up 4 walls with bricks. That doesn't pass the mustard. That doesn't pass the smell test. It sounds almost like a little dirty there. That it goes. I'm not going to comply. I'm going to send a certificate of compliance, and cross my fingers they don't respond. Hence my question: do you have evidence that there was a request for the city to go out and inspect, and that inspection did take place?
I can, not with me, but I can get evidence. I was told that they were notified, and they didn't.
But you weren't there, right?
What's
so
that?
We need actual evidence. Do you have a witness that will testify to that?
But the thing is, obviously the town has to prosecute us, and this is about whether we are in compliance.
I've given you a lot of leeway because
Right, I
I thought
agree.
your argument had merit where you were going with it.
Right.
Because as you know, the order was already entered, and this is at the fines, at the stage of the fines.
Correct.
So that's, again, and I thought your argument, you were heading somewhere.
Right.
And that's why I gave you the leeway you did. But right now, you're making an argument that you don't even know if they called out for that final inspection.
Yeah, well, we
And that would be something that would be pretty important for you to have with you here today.
Madam Special Magistrate, just, to hopefully clarify, and so we're clear on the record, is that
Yes.
on direct examination, Officer Stout testified that access has been denied, period.
Yes. And the documents actually evidence that was the case, hence my question. I want to give him the opportunity to say, because what he said was, oh, that was a lot afterwards, after the certificate of completion would have been issued by statute. But there's nothing telling me that there was an attempt for the town to make that final inspection, that it passed, and then the town just sat there and never issued the certificate of completion. Because it seems like we are completely missing a very important step here.
Did Mr. Town Attorney ever agree or disagree that the town issued a notice of deficiency? Because if
That's not my question. How are
Wow.
they going to issue a certificate of deficiency if they haven't had the opportunity to go ahead and do that final inspection?
And
Correct.
to that question, yes, and we will, when council is finished and as part of our rebuttal, and my legal argument, we will point that out to the special magistrate as it's set forth in the materials that the special magistrate's already been provided.
Okay, so I'll allow them, if the inspections, their position is they were blocked from inspecting, then the statute requires them to issue a notice of deficiency stating that they cannot approve our request for certificate of completion because we did not allow them to inspect. So therefore, we did not satisfy the statute. But, once again, I know this is, we're going down, and I agree with you, Madam Special Magistrate. You have allowed the full picture because I think you want to get this right. So I appreciate that. But I will tell you, today is about imposition of fines and whether or not we were in compliance. And we clearly have a building permit, and I believe that permit clearly addresses the very specific violation that was in the notice of violation and in all of the backup materials and in the code requirements. So we have satisfied our obligation to comply the specific violation, work without a permit, by getting a permit issued. So I don't believe we're in a position to be fined. I don't believe we're in a position to have our property not in compliance for work without a permit. Now, if the town has some other position or some other issue that we didn't have, then they need to legally cite us appropriately and start a new case, but they can't piggyback these issues on a case of compliance where we have a permit that was issued for a violation that was work without a permit.
Well, let's see what the town has to say, but I do want to point out the order actually had two prongs. One of them was going to be the issuance of the permit, and the other one was the property remaining unoccupied. But let me hear from the town attorney if you're done with your argument.
Yes, I'd just like to reserve a few minutes to speak or rebut afterwards.
Okay.
Thank you.
All right.
First, I guess a couple of evidentiary issues. The testimony that's been presented today and that the special magistrate has, as well as the prior order, is that the violation was finishing out the below flood elevation area as habitable space. Anyone can apply for a permit to do work below the base flood elevation area, but it still has to comply with the requirements of the code. And to the extent, this is a legal argument, to the extent that a permit was issued, and it was issued in mistake, case law is very clear that the property owner cannot rely upon that permit that's issued by mistake. To the extent that the permit was issued, as testified by staff already, the permit was issued consistent with the plans that were submitted that did not show the build-out of the base flood elevation area as habitable space. because we cannot allow that under our code. And there's been no evidence presented here this afternoon to the contrary. I also, as a legal argument, would assert that the opposing counsel's reliance upon the private provider statute is an improper attempt to conflate the requirements or the provisions of that statute with another state statute under which we are actually here today, which is Chapter 162, Florida statutes, which very specifically states that there's a procedure that has to be followed for code enforcement cases. Let's remember that's what we're here for, and that your Honor's order, which I presume the property owner has a copy and provided to Mr. Dickerson, very clearly states that it's the responsibility of the property owner to request a reinspection for the determination of compliance of the code violation, not of the building permit, the code violation. And that has not occurred to date, as is testified by Officer Stout. Now, with respect to the allegations of, well, we issued this, even if the state statute on private service providers did apply, the evidence that we've provided to Your Honor contradicts the statements of counsel and presumptively his client. On the materials that we provided to you, I think they're numbered. It's the permit file. On page on page 6, and it has the permit. This is the city's records. The status is waiting on resubmittal. And the reason why that's extremely critical, Madam Special Magistrate.
Excuse me, Madam Special Magistrate, if I may interject for one moment, can I have a copy of this so I can follow along, please?
You can object? What's the basis of your objection?
I would like to object that there's being evidence proffered that I haven't had an opportunity to review.
Sure.
Okay, provide the copy.
So objection, just can we please set a foundation? Is this a document that was provided to the respondent, or is this an internal
Like I said,
town document?
okay. Like I said early on, that the rules of evidence are fine, are very lax. Let's go ahead and hear from counsel, and then if you want to go ahead and ask somebody from the town in regards to the receipt or mail out of that document, you can.
So
Thank you.
at least a significant portion of what has been provided is actually copies of what was submitted by the property owner to the towns, the permit file.
Okay.
And so all of this material is available and was provided to the town by either the property owner or the property owner's general contractor. It's the permit, it's the interior model application. And if presumptively submitted to the town with authorization of the property owner, I would assume, since his signature is attached. And nowhere does it indicate that the work is going to be building out livable space below the base flood elevation, nor do the plans that were submitted indicate such. Just as importantly, on page 21 of that information, several months after the putative indication that the project had been finished out, the property owner submitted a permit revision application to the town asking for additional work. It's to relocate the electrical panel as required by inspector to meet clearance requirement. Certainly, we don't know that we suspect that the inspector that's referenced there is the private provider because we were not asked, to the best of my knowledge, to do that inspection. And look there on page 24. 1, 2, 2.5 pages of comments provided to the property owner as to what was wrong with the plans that had been submitted. There was also similar notations earlier in the file, contemporaneously with the submission of the document of the certificate of completion, indicating that the day after that, the applicant was informed of deficiencies, and the notation on page 7 at 5/17/2021, acknowledgement of flood regs required prior to CO. So not only were there communications about this issue to the property owner, but it appears, according to the records, that the property owner acknowledged, or their general contractor acknowledged that issue.
Objection, if I may, I still don't.
Basis.
They just handed me a whole lot of documents. I don't know where he's referencing, so I can't follow along. Because I've asked the question of, did they notice us of deficiencies pursuant to the requirements, giving the chapters, and I
Wait,
haven't.
are you going back to the certificate of completion?
No, I just haven't seen any of these notices that they're saying that they
Okay.
communicated with us. I haven't
Here,
seen any of
let
that.
me give him,
She's got it.
And I apologize to everybody in the
I
audience.
thought the file was
Typically,
up.
they
I
don't take
apologize, Mr. Jacobs. I thought
that
you were
I
long.
just
following
didn't know.
along.
I didn't know if you were
Of
going
these
page by
cases.
page. I just got a file full of
well, no,
documents.
they're numbered at the bottom.
Okay, so you're on page, what now?
Starts page 6, the first
Page
page.
6. And you're saying this was a document that was specifically sent to the client, or
No,
this is an internal
this
town
reflects
document?
the communications between staff and the GC with respect to the project as a whole.
But this is just the staff putting this information in. This isn't confirmation, so this isn't confirmation that what is said is accurate, right? It's just what that one.
There's been no evidence
But-
submitted to the
but
contrary.
I'm saying, but he,
Council, again, their business records, the rules are lax. I'm going to allow the
Okay.
documents in. You can ask about the information contained in the document. You can contest the validity of it, but at this point in time, I am going to allow it in as a business record.
okay.
So the point being, Special Magistrate, is that the record is replete of instances where staff communicated concerns and issues and deficiencies. And just as importantly, and I think very critical to this entire argument that the property owner is asserting here, is that they themselves came in and submitted a permit revision after they submitted the certificate of completion for the same permit, which was submitted 3 months later. And there are very specific comments in there, and there's a letter that was actually sent to the property owner from staff indicating the deficiencies.
I'll save you time. The certificate of completion argument, I don't buy it. That one's out the door. However, because the violation was a work without a permit, and the issue was whether they could get a permit or not, I want to hear from the town in regards to how does that reconcile the fact that the permit was issued. So for purposes of today, I'm going to go ahead and make the record clear. One, like I said, the certificate of completion argument, I don't buy it. Out the door. The argument, for purposes of, not only am I not buying the certificate of completion argument, if there was a problem with the order when it was originally entered, the appellate rights have expired. So today here we're on fines. The argument by counsel regarding the issuance of the permit is a valid argument because it would go to the date where the fines are to be accrued. So that's what I'm pinpointing here. Whether at what point in time was the property brought in compliance, and if so, how, and if it wasn't, why it's still out of a compliance when the requirement would be to either get the permit or remove the violation. It seems that they did get the permit. So I want to hear from the town in regards to why the evidence that there is a permit that was issued, not the compliance pursuant to not only my order, but to Florida law.
Special Magistrate, I think that's a question that needs to be made, with all due respect, that needs to be made by the property owner and their private service provider.
They did.
Okay.
He actually raised that. He did raise that.
I know he
and,
raised the issue, but he...
several times
But he's...
about the existence of a permit that was in fact issued.
Okay, so we have not been provided access to the site to verify at any point in time, either under the private service provider statute or under Chapter 162 to verify that the work being done is in compliance with the permit that has been issued. The town is not denying the existence of the permit. What the town is here representing to your honor and presenting competent substantial evidence is that we have not had an opportunity to verify that the work has been done in compliance with the permit, and therefore there isn't compliance. And specifically to the issue that has been raised, and we'll print this out and provide it to your honor as well as to opposing counsel. There is a communication between the town, the building official, about this issue, wherein the building official specifically informed the contractor and the private service provider an email where, just to summarize, the building official informed the private inspector, our permit case shows we are needing our floodplain acknowledgement form submitted as a permit condition. Also, per my last email, a revision for the electrical work not in the original scope is needed to complete the construction documents along with fees. So, over a year ago, during this entire time period where the certificate of completion was submitted, there were active ongoing communications between town staff and the private inspector that the project had not been completed as required.
Madam Special Magistrate,
Let me see. Let me find out first
Yes, ma'am.
are you done with argument or?
Yes, sir. Yes, ma'am.
Okay. Let me hear from the respondent.
so I'd like to say a few things. My position is clear that we have notified the town of inspections, and at every step of this process, they've been part of the process. And I don't think it makes sense that they have all this evidence of communications and things that they're asking from us for and all these other things, and clearly we're submitting things. The record's clear with all that for years now, but then we decide to block them from an inspection. The inspection process is, I believe you call the town and you ask for an inspection, and then they come or they don't come. So I don't think it matches that in their record, we've done all these things and submitted these things, and they've had communication with us, and we've had communication with them, but then we just decided not to let them know in the inspections. That just doesn't sound right to me. And the other thing I'll state is, Counselor stated that the permit could have been, or he made a reference to the permit being issued in error. I don't think there's been any competent or substantial evidence that the permit was issued in error. So, and also, I don't believe there's any evidence that the permit was ever revoked by the town. So I don't think it's appropriate to state here today that there's a problem with the permit when, and that the permit could have been issued in error and everything, when not only did we get a permit issued, but we've worked for now years under that permit to get work done with, as they stated for the record, communication with them every step of the way. So I don't think they can, in good conscience, state that there's a problem with the permit and the permit being issued. And while, for the record, I don't concede the certificate of completion argument, I'm smart enough to see that you have narrowed down on the permit issue, which I do believe is the most appropriate issue for this hearing. And I think it's clear that the permit was issued. It's never been revoked, so I don't think there's any competent and substantial evidence that it was issued in error, that there's anything wrong with the permit. I think, to the contrary, the competent substantial evidence is that the town, operated as if the permit was active by continuing to work with us for the last several months, if not years, through the permitting process to get this work approved. And the face of the permit is clear. The language on the permit itself tracks the exact language on the notice of violation. And it tracks the language. So I don't think they can state that we did work outside of what was intended for the violation. The violation had very specific language, and the permit had very specific language that was issued directly in line with what's on the violation. So I believe we were in compliance when we got the permit issued.
All right, so let me go ahead and because there was a second issue and I raised it and nobody has addressed it yet. The order is two-part component. There was a coming into compliance by the homeowner, by however means necessary, and that was contemplating whether they could get the permit or not due to the FEMA guidelines. The order has a second portion of it which says the space is to remain unoccupied. I haven't seen or heard any evidence regarding whether the space remained occupied.
I would
and
like
I'm gonna, again, because I remember the reason, I want to make sure that the record is clear, that I remember the case very vividly. This is a property that is getting rented on the short term, it's a rental property, and therefore intended for occupancy. And the argument here today, basing it back to when I entered my order originally, the portion where I said the space is to remain unoccupied was entered for a reason. And that reason is that because there is no permit, and this one not only came without permits, it came with the issues of flooding, and here we are just a couple of months away after Hurricane Ian. That was a flooding event. Again, puts a highlight on that reasoning of why I precisely put that into my order. The space is to remain occupied. So has the space remained occupied? Unoccupied.
Madam Special Magistrate, I want to state for the record that the ground floor space has remained unoccupied for the entire time since you stated that. So the two-pronged components of the order were get a permit and don't occupy the space. We've satisfied
Correct.
both of those conditions.
Now, so even sitting here today, given the fact that I understand your argument about the certificate of completion, I don't buy it. My question is, as of today, has that property, ground floor, which is the issue, remained unoccupied?
Yes, the ground floor has remained unoccupied and is unoccupied today.
Okay.
Certainly, since we haven't had the opportunity to inspect the property, we can't contradict that. But what I would inform the special magistrate, and it's part of the file, and I've informed opposing counsel this prior to today's hearing, is the property is currently on the, there's a listing for the property to sell it on the MLS. And it very specifically says that on the ground floor, it is built into 2 separate units. And they're selling this as a home with 2 units, livable space on the ground floor, and 3 bedroom unit on the second floor.
I understand, but and I agree. I'm not disagreeing with the town in reference to the issue. There's no certificate of compliance. There's no verification about the materials used to see if it was in compliance with FEMA. I get all those arguments. That sounds like it would be a separate violation as opposed to one that we can piggyback here, because that order had a two-part component, coming to compliance, and it sounds like when they issued the permit, that portion of the violation was cured.
Well,
I think that there's a great argument for the town to issue a new case in reference to the fact that the permit has expired and there's no certificate of occupancy, which I think we already can anticipate what council's response is going to be, but I'm not exactly sure whether within the 4 corners of that order that we can expand into the requiring the property owner to close out the permit. This one is interesting because it has those FEMA requirements. It also crosses over a little bit into federal law in those aspects. But when it comes to the violation itself, which was building with a permit, and at the time of the hearing, we contemplated, hey, listen, they might have difficulty. Hence, why the order was drafted the way that it was, coming to compliance, whichever way it is. Just keep it unoccupied until either everything's removed and it comes into compliance in that fashion, or they get the permit and they get the certificate of occupancy.
Right.
But given the fact that I have testimony from, well, not argument from counsel, I haven't seen testimony, but he has represented as an officer of the court that the property has remained unoccupied and the town does not have any evidence to the contrary, it seems to me that they have come into compliance.
And Madam Special Magistrate, I'll state that
I want to hear from the town first.
Yeah, Madam Special Magistrate, with all due respect, I believe that the issuance of the permit argument is frankly for lack of a better description, a bait and switch. And here's the reason why. The permit application that was submitted by the applicant, in which permit number 210808 was issued, from which the property owner is asserting reliance upon for the proposition that they're in compliance. The actual plans that were submitted do not show the work that has been done to the downstairs area as has been testified here today. They exceeded the scope of the permit. It's not shown on the permit application that this area is, in that the downstairs area for which this permit was issued for the putative remodel, including the build-out of livable space. If you look at at the plans that were part of the permit application that start on page 10 of the material, and they're marked as permit number 210808, the area that is the downstairs is not shown as livable space.
And that, I brought that up before because I'm looking at it. There's in fact a reference to the little amount of text that I can see, there's a reference to a garage door, and made the point that there is no, there does not appear to be any bathroom, which leads me to believe that what the inspector was saying regarding it being storage might be the case.
And that's our assertion. There hasn't been compliance, notwithstanding the issue of the permit, because the work that has been done exceeds the scope of the permit and is not in compliance.
And Madam
We
Special
never
Magistrate-
would have issued a permit that would have allowed the build out of the area as livable space, because it's prohibited by the code.
Madam Special Magistrate, with all due respect, that argument exceeds the scope of the ordinance. The ordinance says to issue a permit. We've been at this now for years. We've been at this for years. So if they had an issue with the permit and whether it had, that's the only reason we went after the permit.
How could we know if the permit, the work was being done if we didn't have
Hold on.
access to the site?
I see that. Again, something that I raised early on was the issue that I was not sure whether livable space downstairs or not.
No, ma'am.
No, it wasn't.
No, it was not.
So that was.
No, it wasn't.
It was always.
The
would you like
position
to-
of the
would
town
you like
has
to
always
investigate?
been, excuse me, the position of the town has,
If the code officer went by there, they knew that there was work inside that was done. How did they know that? They obviously looked in the window, observed the property. If you sit by a property for a few minutes, you will see people coming and going. You will see vehicles. They know
Special
that this
Magistrate.
property. They know that this property is
Hold on.
unoccupied. They know that this property is unoccupied, and it's been unoccupied the whole time. So I don't think it's fair for them to try to muddy that water. The property's been unoccupied this entire time.
So hold on. The plans that I have in front of me that were the source of the permit that was issued includes remodeling for the upstairs, which the town never said you can't. And the first floor, again, the upstairs looks like an interior renovation, which again the property owners would be allowed to do because it is habitable space. It has been allowed as habitable space by the town. Not a problem upstairs. The problem is downstairs. And
That's a good
what
point.
I'm looking downstairs is not habitable space. So the permit that was issued was for interior renovations upstairs
Madam
and
Special
a
Magistrate.
square box with a garage door downstairs.
I'll
And I
say-
think the town has a good point in questioning whether that is in fact what's there or whether they are
That-
trying to pull a fast one on us,
that's
saying
fine.
that it was permit for upstairs for interior remodel, so that everything says interior remodel, then do whatever you want downstairs and then use the code for the certificate of completion without ever calling for a final permit. Oh, we send the final completion, you can't come in, it's done.
Right. Well, I'll tell you, first of all, to your point exactly, I think what the town stated earlier contradicts that position, because remember earlier they read notes about requesting floodplain information from us and flood risers or something. So if we're talking about flooding, we got to be talking about the first floor, right? You can't be talking about some of the things that the town attorney stated that there were comments about additional documents that they wanted, additional information. This was flooding documentation.
That wasn't, I'm not relying on counsel's argument.
No, but what I'm saying is,
what I
that-
just said had nothing to do with counsel's argument.
Right.
What I am talking about is the plan that ended up with the permit that you are arguing cures this violation.
Correct, and
Now,
my
even
position-
went the route, listen, if they have the permit for it, then great and dandy. My question now is in reference whether the respondent has a permit for work in that first floor, making it habitable space. That's my question. Very clean.
Yes,
No.
Where?
the permit number. Permit number 210808 for
right.
interior remodel, authorized remodeling and renovations downstairs. That's our position, and we believe there are comments that talk about requesting additional
I'm
information.
not talking about the
floodplain.
comments. I'm not talking about the comments. Forget about the comments.
Objection, Your Honor.
Wait, what? Counsel, hold on. Forget about the comments. My question is making that habitable space. The plans that were submitted for that application does not have that as habitable space. Can you represent as an officer of the court that downstairs was not built out as habitable space contrary to what was submitted to the county in the plans to get that permit?
Well, it's been represented to me that,
No, that's not my question. Have you been to the property?
no, I have not been to the property.
Do you have any pictures or witnesses that can testify that downstairs was not built out to become habitable space contrary to the permits that were submitted for the permit application?
So are you saying that because the permits,
I'm looking at the plans right now.
okay, if you maybe give me a moment, because this whole thing was about the downstairs and remodeling the
Correct.
downstairs. So and that permit was issued for that reason, to address this
No.
specific code violation.
That is incorrect. That is a misrepresentation, because the plans that were submitted to the town that resulted in the issuance of that permit was for interior renovations on the upstairs and what appears to be storage space on the bottom, which even includes a garage door. So are you telling me that the downstairs showing a garage door and what appears to be storage material with interior remodel upstairs, that all of a sudden, because they did a permit for interior remodel for the upstairs, that automatically granted the right to go ahead and do the permits downstairs? And never mind, you can't see the interior because I sent you a certificate of compliance. You ignored it, so I get it issued, in order to prevent the city from confirming that is in fact being used as habitable space when it's not supposed to.
Madam Special Magistrate, may we take a 5-minute break so we can get this information?
We have a lot of people in the audience. You can take a 5-minute break, but it's going to be longer because we're going to call the next day, the next case. This is not fair on the rest of the people that are here.
Madam
So I'm
Special
going to go ahead and I'm going to allow the break, but I'm going to leave you guys to the last to the end of the last of the hearing.
Can I make one comment, Madam Special
Yes.
Magistrate? Your point, the issue that you just raised, I had this specific conversation with Mr. Dickerson yesterday
Understood.
afternoon.
Let's go ahead.
I said, bring in photographs showing that it's not habitable space. Give us access to the property.
Hold this one till the end.
Thank you.
Thank you.
Next case.
Our next case is number 6, 20230-399 with Remove It Pros for mangrove tree removal without a permit.
Is Mr. Schutz here?
Let me get that file.
Thank you, Madam Special Magistrate. The next case is,
Are you not present?
no, is the property owner here? Boulevard, and the code inspector officer is Chad Schutz. With the special magistrates? Okay. Your special magistrate, I've been informed that 6 and 7 are essentially the same. If you wish, we can present them at one time. The distinction is that the contractor was cited for the violation as well as the property owner, which is case number 7.
Oh, got it, okay.
Okay?
Thank you.
So the property is located at 6425. The property is owned by Estero 4148 LLC. And the contractor that engaged in the activity is Remove It Pros Inc. Chad Schutz to present the town's case. Mr. Schutz, can you please state your full name for the record and your employment?
Chad Schutz, Town of Fort Myers Beach Environmental Staff.
And in that capacity, are you responsible for enforcing the portions of the town's code dealing with environmental matters?
Yes, sir.
Does that include Land Development Code Section 4-455?
Yes, sir.
And what does that section of the code state to the best of your knowledge?
It states that no person or any agent or representative thereof, directly or indirectly, shall alter any mangrove tree located in the...
5 Estero Boulevard.
Yes, sir.
How are you so familiar?
I was notified on a weekend in February, I believe the weekend of February 19th, by code enforcement officers employed by the town at the time that there was dredging and construction activity at the Beach Theater located at the address.
Okay. And did you inspect the property as a result of that complaint?
I did.
And what did you determine as a result of that inspection?
That the vegetation had been removed and there was evidence of red mangroves that had been altered or cut at the trunk.
Did you have an opportunity to make contact with the property owner or any other individual on site or further investigate the matter?
All the work was done over the weekend. After the citation was issued, I believe that's when I made contact with the owners. I'm not.
Did you have an opportunity to, as part of your investigation, inquire with either the property owner or with the state as to whether or not a required state permit for the removal of the mangroves in question had been obtained?
No permit has been issued to date.
Under the town code, is mitigation for these types of actions required as part of the remedial action that a violator, presuming the special magistrate finds there to be a violation, that they have to undertake?
Yes, restoration standards are listed in section 14-454.
And did you have an opportunity to issue a notice of violation or notice of hearing to Remove It Pros Inc. and Estero 414 LLC? 4148, I'm sorry.
I believe it was a citation for irreparable and irreversible damage was issued to both parties, yes.
Okay. What follow-up have you had with either the property owner or the contractor?
So following up with the property owner, they indicated that they intend to construct a seawall along the property line that borders the canal there. I also spoke with the Department of Environmental Protection compliance officer Alexandria Martinez regarding the issue. And there are, right now it's under compliance, or in compliance with, in the compliance department, I don't mean to say in compliance, but compliance staff with the Florida Department of Environmental Protection is reviewing the case and to submit seawall plans to, or have submitted seawall plans to the Department of Environmental Protection under the 1996 Mangrove Trimming and Preservation Act. Mangroves that are removed or altered while doing a exempt or permitted activity are allowed to be altered. Having said that, they would still need to be mitigated for with the U.S. Army Corps of Engineers if what I believe to be is going to be the series of events that follows that submittal of a seawall. That's what they'll be required to do since they didn't mitigate with the state.
To the extent that the citation specified a irreversible violation, was there a fine associated with that violation?
Yes, a $5,000 fine was issued to Remove It Pros as well as to the LLC property owner.
And have those been paid?
My understanding is yes.
What is?
It has been paid?
Yes, ma'am.
Yes, the request, however, Special Magistrate, is to not only set a time frame for the property owner and the contractor to obtain the necessary permits, but if they do not do it within that time, that there would be additional fines. This is authorized under the code for you to impose, separate and distinct from any action that the Army Corps of Engineers or FDEP may take against the property owner and the contractor. Nothing further.
Now, really quickly before we have the respondent, that payment was it made directly to the town, or was that made directly to the Corps of Engineers?
It was made to the town
Or
for the
the
citation.
Department of Environmental Protection?
It was made to the town. To pay
Okay, so it was related to the
citation.
town, okay, so
To both.
there was anticipation that there was irreparable harm, and they went ahead and agreed to it and paid it?
Yeah, I
from the
believe
get-go.
they're still under investigation or, the compliance procedures with FDEP.
Got it. I just wanted to, because a lot of times I think this is the first time I've ever had one with irreparable harm where the fine, it will become part of my order to the extent that if it was already paid for, that I'll put it in, but it's already been paid. That's why I want to get clarity on. Okay. Anything else?
Nothing at this time.
Do we have somebody here present for the respondents?
We do.
Contractor or property owner or both?
I believe just the property owner.
Okay, please come up, state your name and relationship to the case, please.
Corey Nanke, property owner.
Okay.
Steve Bowden, property owner.
All right. So it sounds, based on the testimony from the town, that you guys know that you guys are going to be encountering some issues going forward in reference with the Department of Environmental Protection, the Corps of Engineers, and of course the town. Now that payment was made in anticipation of the irreparable harm order.
No, the payment was made because it's a solution to move forward with the process of the seawall.
Okay, so in order to get that permit from the town, that was paid as
Right,
part
and
of.
we were also told we shouldn't get a permit by the state, correct? By Alex.
All right, yeah, I'll get into that for a second because that's another whole ball of wax there. Okay, all right, so obviously you guys have spoken already with the Corps of Engineers in reference to the seawall. Where are you in that process?
So we've submitted,
Ready, please.
yeah, Steve Bogan, I'm one of the property owners.
Okay,
And Corey Nanke, one of the property owners.
okay, perfect. Okay, so that those plans have been submitted regarding to the seawall to the Corps of Engineers.
Yes, to the DEP.
Where are you guys at in reference to the environmental portion, the submitting the restoration documents to the Florida Department of Environmental Protection?
So we've submitted the documents to the DEP, to Alexandria Martinez. Essentially, we wanted to go through this and figure out what exactly we needed to do. We're not exactly sure what the next step is.
When were those documents submitted to the DEP?
She reached out to me probably a week or two after the violation.
Did they provide you with a timeline of how long it's going to get for them to review and come back with your approval of the plan?
She did not.
With everything going on, there's probably a good backlog even worse than it used to be. Mr. Schutz, do you know how backed up are they, by any chance?
Compliance with the EP is always tricky. They don't have the same statutory time limits to review, so I can inquire. I believe that getting the exemption for the seawall should be fairly quick with FDP. However, they will not likely receive a state programmatic general permit, which the state can issue on behalf of the feds. But whenever there's mangroves involved, and especially if it's gone into compliance, I believe you don't qualify for that SPGP and therefore have to go directly to the Corps, which is also a lengthy process.
So obviously you're more knowledgeable with the process than probably any of us here. So we have two moving parts. One of them is going to be the environmental portion regarding the mangroves, and of course the seawall one, which you think is going to get issued relatively quick. There's going to happen in terms of the mangrove portion.
I believe the town would still require state and federal permitting, even if it's
The whole
exempt-
package.
Even if it's exempt with the state, it would still require the federal permitting portion before they could commence with the seawall.
But my question is, let's say they get the federal go-ahead in regards to the seawall portion, but we're still lagging on the environmental portion. Are they going to be able to proceed with that seawall, or is everything on hold until we get that clearance from the DEP and the clearance for them to do the seawall? So I'm trying to gauge the timelines that we're working here.
Right, so I'm not aware, I'm not sure if I completely understand your question, but I'll try and
All right.
answer.
So the question would be, one of them is going to be regarding the mangroves, the environmental destruction of the mangroves, and having to put it back, some type of plan to mitigate that environmental issue. But we also have the actual construction of that seawall, which was what gave way for the destruction of the mangroves in the first place.
Mm-hmm.
So in terms of timelines, of course, we're going to have, it seems to me, that we have two moving parts, because one of them is going to be the construction portion of the seawall, which would be, again, with the feds and the town in reference to the issuance of permits and the green light for them to start building the seawall, and then deal with the mangroves issue, or whether it is all going to be one big ball of wax that has to be, everybody has to kind of agree. All
Staff perspective, I'd like to see, the seawall plans, nothing's been submitted yet, as well as any dock plans, and just get a more comprehensive understanding as to what their plans are for their property. And then it's also important to note that mangroves were altered both on their property and in town right away. So there's kind of two separate issues there. But ideally, that mangrove restoration would be incorporated into the
and that's the
design of the
idea, but
seawall.
obviously, given where we're at this point, which is not ideal, but this is where we find ourselves, it seems that the construction of the seawall, absent the everything going okay with the seawall, with the feds and the city being able to issue that permit, allowing them to be the seawall and deal with the mangroves after that seawall is built. Which
Again,
kind of, it would allow for two things happening at the same time. They can get the approval for, because I have a feeling the approval for the seawall is going to come faster.
Yeah,
So
I mean,
we
the-
might get the approval for the seawall to proceed, so they can go ahead and take that, and then once that's completed, by then hopefully the DEP has made its determination as to what the restoration is going to be, and nobody has to wait for that seawall to be completed. They can just go in immediately thereafter into the rehabilitation portion.
Right, so DEP is likely going to issue them
That'd
an
take longer.
exemption and not require any mitigation. The Corps will likely take some time, maybe on the order of 3 months if they submitted their application today, maybe longer, if it's a complete application.
Oh, so you think the Corps is going to take longer?
With mangrove mitigation, likely for them to get all their paperwork in order with that. And then with the seawall construction, whenever they would submit a seawall plan to the town, they would also be required to have a habitat creation with a new seawall. And, staff would ideally like to see the mangrove habitat creation.
The property owners, have you guys engaged a professional to go ahead and help you guys with the, especially the environmental portion, the submissions to the DEP?
We have not yet. We're-
And I'm sorry, I know the paperwork was submitted, but were the actual plans for restoration submitted already?
No, not to the town, no.
Okay. So you might, again, I don't dictate what you guys do. I can't tell you what to do. You might want to go ahead and start looking at finding somebody that might help you through that process. It is my understanding, and again, I've never gone through it personally, but it not only lengthy, it can be a little complex for your average person to go ahead and go through. But again, I can't dictate what you guys choose to do or not, but I am anticipating that absent somebody who knows what they're doing and getting it through, it might take a little bit longer because you're going to start going back and forth and a lot of frustration. And as you know, the town is here not only on the violation, but more for purposes of getting those timelines set up and make sure that you guys don't start accruing fines on a daily basis because you missed a deadline.
Right. Yeah, I mean, but at this point, we'll certainly plan on having somebody help us with that process.
I'm sorry, could you say that again?
At this point, we'll certainly have somebody help us with that process.
Okay. All right. That might be a good idea. All right, so it looks like for the DEP, we're looking then at June. We are in 2 months. Something tells me it's going to be 3 months. Don't ask me why. That's July. And then we think the feds are probably going to take an additional 3 months to do it. And the two.
Well, they can apply for the permit with the city right away. It can all be done concurrently.
Wouldn't they need, didn't you say they would need in the permit application with the city for the seawall, they would need the restoration plan incorporated into it, correct?
Right, so they could submit the seawall plan, the dock plan, the restoration plan all together, and that could be approved with the condition that they can't commence until state and federal permitting is obtained.
Got it. But the question is, though, what if the DEP comes back and says, yeah, no, what you guys are proposing is not going to work, you got to do this?
Again, DEP is 99% going to issue an exemption, and then the mangrove
Okay.
alteration is
Okay.
also exempt, but the
All right,
Army
so
Corps is going to be the bottleneck.
The issue. Perfect. Okay. All right. So my inclination right now is to put a deadline of 3 months to go ahead and complete everything. But I do want to go ahead and get a status into where things are, maybe at the next hearing, so that we know that things are moving, as opposed to stalling and then a couple of weeks later they're scrambling and the town is not seeing any movement. And that would be just for the permit issuance. Let's see, for that seawall. Or do you think that's a reasonable timeline, Mr. Schutz?
To submit permits, I think if they engaged a professional, they could submit permits within a month.
I would probably be concerned about that.
It's just to submit, right?
To the town or to the?
No, the problem is they would have to, I see what you mean. Everything would be on hold till then.
Is that just to submit to the town?
Yes, submission to the town of the permit application, then it would basically stall until everybody else puts the seal on it. Because you won't be able to they won't be able to issue the actual permit until everything is in line. So we're trying to figure out a way where we can have 3 things moving at the same time. Your seawall with the restoration portion submitted to the town for issuance of that permit, again, pending the DEP and the Corps agreeing to what has been submitted in order to expedite things coming through, with the holdup being, according to Mr. Schutz, that the Corps is going to be the holdup. So we're trying to move things along. My inclination right now is still on the 3 months, and they use that time whichever way it is they want to use it. I mean, you've definitely given them a fantastic suggestion about trying to run things simultaneously, based on your previous experience with the DEP and the Corps in regards to those approvals, especially the DEP approving the acceptance. In 3 months, we're done.
Town attorney, you
Any
okay with
comments?
that? Yep.
Comments from the city in regards to that?
If it's acceptable to staff, I mean, I don't have, you know, in these particular cases, historically, Madam Special Magistrate, it's a question of how much time you feel, given the particular circumstances after hearing from all the parties, what is a reasonable period of time for the property owner to come into compliance.
Yeah.
Because there's no dispute with regard to that the violation occurred. And so, you know, I defer to your Honor's judgment after having heard from both parties, the staff as well as the property owner, as to what is a reasonable period of time.
I mean, just to
Yeah,
note, I mean, we're very motivated to get it done, so we'll get on it as quick as possible, engage who we
Yeah.
need to engage. And
You definitely don't want to wait until the last minute on that, and hence the reason that I'm giving you the 3 months. You use it whichever way you want, but that should give you plenty of time to get all your ducks in a row if you move and keep things moving, and like the town suggested, on trying to do things kind of running at the simultaneously at the same time and then merging them at the end on that. Okay?
Madam Special Magistrate, what I would ask is, I think historically what we've said is, you know, and if that is what the Special Magistrate is inclined to do, is that we just simply ask that the order reflect that they have the 3 months to apply.
I don't want to split it. I just want to put full compliance with the order, with no extensions, absent absent good cause.
So since we've never been through this process, we have no
Yeah.
idea whether your 3 months is even reasonable. So,
But hence the reason that I've asked about whether you had hired a professional, and here we are. You've known this has been running, and you haven't hired a professional to answer those types of questions
We have
as to how long it would do.
Yeah, I think,
I'm sorry?
to apply within 3 months, definitely very doable in my opinion.
Well, I'm not saying
But
apply. I'm saying full
to-
compliance.
Right, so
there is no way we'll have full compliance in 3 months. That's
Yes.
impossible.
Why not?
to get
Simple
permitting,
response time.
to get permitting from the Corps is going to take
Special
3 months.
Magistrate,
We just had this discuss. I just had asked all those questions. I just asked Mr. Schutz, and we have based on his experience. And again, this is not the first one I do of this type. It's the first one that I've done where people have paid the irreparable harm before they come to me. But this is not the first type of case we've handled here, so I'm aware about the timelines. Hence why the immediate suggestion was run the 3 things simultaneously. And that sounds like my first question was a valid one. You might need a professional to help you with that.
we're planning on hiring a professional to help us through this process.
Yeah.
I mean, you call somebody and they'll be out in 3 weeks to come out and visit the property, and
Exactly. And again, it is on that's what I'm saying, with no extensions, absent good cause, because I also understand that you're at the mercy of other people. And I get that. But I don't want to go ahead, and hence the warning of you might want to hire someone, of coming down 2 months later, or at the end, or at the end of the 3 months, and you're telling me, it's like, oh well, we didn't know what to do. We kept sending stuff, and it kept bouncing back. Hence why I have to go ahead and put strict timelines on this and give you the heads up that you might want to do this. I can't force you to do it, but it might be a good idea, especially in light that you just stated that you have never dealt with this process. Okay.
we certainly plan on hiring a professional.
you know, Special Magistrate, I just, you know, and I think historically, I say this in every one of these types of cases, and I understand and I appreciate the situation that the property owner finds themselves in and the mercy of others, but we wouldn't be here if they had obtained a permit to begin with. Simple as that.
Understood, but unfortunately we can't turn back time, so we got to deal with what we have. And I do appreciate, like I said earlier, they fell on the sword. They admitted that it was a problem, and they paid out the $5,000 fee for the irreparable harm portion. So to that extent, I mean, I wish we wouldn't be here in the house. So.
And you know, to the point, you're correct, Special Magistrate. I think historically you've stated, and certainly the town is representing to the Special Magistrate that, you know, we're not trying to be punitive. If they're
Correct.
working toward compliance and they need additional time, they can always ask to come back before the Special Magistrate and ask for additional time.
Yeah.
And we'll listen to what the circumstances are. But we do, you know, the town does take these type of environmental violations seriously.
Absolutely, no, absolutely, absolutely. So I am still inclined to go ahead and do the 1 month status, given for that exact same reason, to find out where they are in the process, if they have retained assistants, who that person is, and hopefully get them in touch with the town so that the town knows what's happening in terms of that, because at that point in time, professionals can talk to professionals, and they might actually be able to move it a little bit faster, and they'll know where they're going. Okay.
We'll stay in communication
All right,
with
then.
Chad as well and make sure he's aware
Okay.
of what we're doing.
All right, with that said, what is the town requesting in terms of obviously a finding, and what is their per diem?
Certainly, we're asking that the Special Magistrate find that the property, that the violation, that the maximum fine authorized under the law due to the nature of the violations be imposed, which would be $250 a day for each day in non-compliance thereafter. Obviously subject.
I'm sorry,
to
what was the rate? The 250?
250, obviously subject to their ability to request additional time if the circumstances warrant.
That's for
Alrighty, I
per
hear-
diem afterwards, if we
go ahead.
don't meet in compliance.
I'm sorry?
That's for if we don't meet the timeline, each day is 250.
No, what's going to happen is I'm about to enter my ruling. It's going to be reduced to an order, so I'm going to give you 3 months to come into compliance. I'm not going to take how you get there. I'm just going to give you 3 months to come into compliance with no extensions absent good cause. And good cause can mean, listen, we hired this guy immediately, he submitted the document, DP is not getting back to us, or the court's not getting back to us. So make sure that you document everything in case that you need it, because, like I said, I understand that you're at the mercy of third parties, but there's a lot that is within your control, and I want to make sure that those things that are within your control are moving, and that if there is a need for an extension of time, it is something that was completely outside of your control, and not that you sat back and didn't do something you were supposed to do in expectation that you were going to get the extension. Okay? Just so long as things are moving and you have documentation, and you need the additional time because of X, Y, Z happening outside of your control, then we'll address it. But again, I just don't want to start opening the door already. So I hereby find that the violation, that there was proper service, and that the violation as stated in the notice of violation did exist and continues to exist. I'm hereby going to order the property owners to come into compliance within 3 months. Otherwise, face a fine of $250 a day until the violations are corrected. And I want to put the notation regarding my 3-month time period is with that there will be no further extensions absent a showing of good cause. Okay? Is there a request for fees and cost
Yes.
associated with?
Yes, ma'am.
Okay, what is that amount?
I'm sorry?
What is that amount?
How much?
We're requesting $250 for admin fees.
Okay.
As Special Magistrate, we'd also ask, as we announced at the beginning, that there, you know, are essentially 2 cases here, is that we hold the contractor to responsible for additional fees and fines if the property is not brought into compliance, to discourage this type of activity by contractors in the future.
No, absolutely. And like that, they were both joined into the code compliance case. It is going to be jointly and several. So they are tied together to the hip on it, and they are both responsible. If there's no payment made, both would be held accountable. So it is, everything here is joint and several, and I'm going to grant the town's request in the amount of the $250 in fees and costs incurred in relation to this case, to the case, and as part of that assessment for the $250 has been supported by documentation. Okay. All right, I want to go ahead and please include in the order also the, my request for a status hearing in 1 month. For the, well, the next, whatever the next hearing is, because I don't know if it's going to be next month.
So we come back in a month?
Okay, so that, for that, just, again, you both don't, I mean, you can both come in, I'd love to see you in person, but the idea is to see where you guys are at, so.
Would it be possible that we keep chatting abreast of our, we can email him on a weekly basis if we need to, rather than come back to a hearing?
I'd like to go ahead and get we'll do this. I will allow for the town, if the town goes ahead and lets me know that they have been in constant communication and that they're satisfied where the matter is in terms of correction by that next hearing, then I'll go ahead and I'll waive that appearance. But I do want it at this point in time in my order. But I will
Great, thank
allow,
you.
and I'm putting on the record for you guys to, so long as you're in communication and the town determines that there is no need for that status conference because they've been kept apprised and it's moving, then I'll be okay with that waiver. But I'm gonna defer to the town in making that determination. I want to give them that opportunity, and I want to know what's going on.
Next cases, number 9 and number 10. They were separated into 2 cases because we issued citations. And the citation dates are,
Madam
we going
Special
there?
Magistrate, if I may,
Yes.
very quickly, I've had an opportunity to confer with counsel who are here on behalf of the Nature View Court matter that we continued or held in abeyance while they had an opportunity to look into the matter. And after talking to Mr. Dickerson and his co-counsel, as well as talking to staff, what we are proposing is that we continue this case until the next meeting. Indicated to the property owners that if there is compliance, then obviously we will file the appropriate affidavit of compliance. If not, the matter will continue before the special magistrate. And then, assuming compliance is obtained, they have the right under our code to apply for a reduction in the accrued fine to the town council.
Well, at this point in time, obviously the town understands that right now we're just with an order and no certification and therefore no lien on the property, correct?
Correct. No further action would be taken at that point in time. Again, what generally would occur is that an order would be entered saying that, from the initial date of compliance to the date it's determined that there has been compliance, there obviously would be we would request an order be entered that a fine did accrue during that time frame, but we would not record that order and not so it wouldn't become a lien against the property, subject to their ability to or subject to them applying for a request for reduction to the town council.
Special Magistrate, may I be heard?
But is that what the respondent's attorney is also the understanding that is the stipulation between the parties?
It's not quite. So for the record, my name is Tony Lahan. I am co-counsel for Nature View. I was the attorney that was present back in March of 2021 when we had our original hearing.
Okay.
So nice to see you again. So no, our position is simply this, that we are getting an agreement that is continuing the hearing. So there is no finding of non-compliance, there's no finding of compliance. We're going to postpone today's hearing, put it on the next docket. We're going to allow them to inspect because this issue just literally came up yesterday about whether or not we're hearing for the first time they were not allowed to inspect, which we don't agree with, but that's their position. So what we've decided to do was say, come and inspect, and if we agree there's compliance, then it seems to me what would happen, because the compliance would relate back to when we actually got compliance, got the CO way back when, we would be talking about whether or not fines would be imposed and over what period of time, and we reserve all those arguments. That's all that should be happening.
And I don't disagree. Procedurally, I think that the Respondents' Council is correct in procedurally how to do it, because either we walk out of here with it something. If the request coming from me was for the imposition of for the imposition of fines or either certification for it to become a lien against the property, we either proceed or we don't proceed. At this point in time, there's a question regarding whether there was compliance or not, and if so, when. To that extent, I am going to grant a continuance to different hearing. However, with the caveat that I am going to order my order from March 18th of 2021 to be recorded. That does not create a lien on the property. However, it does put any potential buyers, given the fact that this property is for sale, that there is a problem with the property. The last thing I want is to go ahead and have a third-party purchaser purchase the property, find themselves in this situation because we didn't close out the loose ends. If they buy it, being on notice that that order is out there, which again, not a lien, it's just putting them on notice that there's a problem with this potentially problem with this property, and there was a code violation. Then I can go ahead and proceed with that request. Otherwise, I will be entering an order, making a finding as to the violation, making it a lien, and then you can go ahead and make the request for an amendment or a reduction based on that.
Understood, Your Honor. And, Special Magistrate, and for the record, the property is not listed for sale. That's an outdated MLS that council was looking at, and so we understand that's going to be an issue, but I understand what you're doing, and I agree with how we're going to proceed based on what you've said.
Perfect. Then I'm going to go ahead and grant the continuance. However, I am ordering the town to go ahead and record my order from that March 18, 2021 to put the world on notice that there is a potential issue which might not exist anymore because it has come into compliance. But at this point in time, we do not have that answer, and as such, I want to go ahead and make sure that that order is recorded. Okay.
One more item, if I may, and then
go ahead.
I'll turn over the floor. I would like to get notice served on me, an additional copy of notice of any notice of a hearing. I've made an appearance.
Right.
I've been in here. Mr. Heron and I have had a disagreement over time as to whether or not I'm entitled to get a notice because he says they comply with the statute, and so they serve it on the property owner at the property address. I don't have a problem with that. I want an extra copy sent to me because I am counsel of record.
I think as a courtesy, I can go ahead and ask them to do so. I don't think I have any legal basis to actually do that, absent you being the registered agent for the property, and then they'd be required to do so under that fashion. But again, I'll ask them to go ahead and do that as a professional courtesy, but you make sure that your client does stay in touch with you because it would be your client's responsibility to make sure that you get those notices, okay?
Yes, ma'am. And Madam Special Magistrate, just wanted to also state for the record that if we are determined to be in compliance, I'm sure you wouldn't object to a release
of course, absolutely.
of that order, so
yeah.
the public record is clear of that as well.
Absolutely, absolutely. And even when if let's say I issue a fine, I'm not saying I'm going to, I'm just saying, let's say for example we have a fine, the moment that that's paid, then it would get released as well. So yes, that will be addressed. Just remind me just in case, but I think you will, that order was recorded, but absolutely, we'll definitely address it.
Three things, very briefly. One, Your Honor, your code case pertaining to this particular piece of property. Second, staff has informed me and shown me that we have been providing counsel email copies of the notices of hearing, including the one for today. But we will continue to do so. If he wishes for a mailed notice, then we'll do so. But we have been, at his request, because I remember having this conversation with staff when I had those communications, to ask them to provide that to his office as a courtesy. If you haven't been receiving them, I don't
I've
know.
gotten some, and then some I didn't get, and then you told me I wasn't allowed to get them. But be that as it may, as long as I get them in the future, let's move on.
We'll move on. And then last but not least, obviously, if you know the whatever future process or proceeding is really limited to when the property was brought into compliance, and if and when that determination is made, then the affidavit of compliance as required by the statute will in fact be recorded, and then they can apply for a request for reduction in whatever that accrued fine might be that you find the time frame for noncompliance.
Perfect. Just that we just got to make sure that it relates back somehow to that order that was reported. Great. All right. I guess I will see you guys at the next hearing. Thank you.
Thank you very much for the time.
We'll be in touch.
Yes.
Well, you probably want to make sure that the town has your correct email address, just in case, so that they're actually going out to the correct place. Okay.
Yes, thank you, Special Magistrate. I'll
All right.
provide.
Thank
that.
you.
Madam Special Magistrate,
That's right. Yeah.
the property owners, the alleged violators are Matthew and Tricia Oakley. The property address is 280 Sterling Avenue, and the alleged violation on number 9, as well as a separate set of violations is work without permit, the ground level remodel without permits, and just to lay out the predicate here is very similar to the Nature View case that we just heard, same the operative facts, but obviously specific to this particular piece of property. And the town's inspector is Bill Stout. So, hold on, I don't want to, so.
All right. You may proceed when you're ready, Mr. Herring.
The clerk is still communicating with counsel in the
Oh, okay,
prior
sorry.
case, so.
And Special Magistrate, my name is Anthony Melchior. I represent Mr. and Mrs. Oakley, the property owners here. And
Great.
I would just have to disagree with Mr. Herron that this.
Well, hold on. I need to let the city present first, and then we'll go ahead and.
I thought that was the opening. I apologize.
No.
Officer Stout, you've been previously sworn in, is that correct?
Yes, sir.
And you are employed by the city of, or the town of Fort Myers Beach as a code inspector?
Yes, sir.
Are you, as a code inspector, are you responsible for enforcing the town's regulations, including section 6-111 of the town code, which adopts the Florida Building Code?
Yes, sir.
Are you familiar with the property at 280 Sterling Avenue?
Yes, sir.
Can you please tell the special magistrate how you are so familiar?
I've been with the town for 7 years. I know quite well about 280 Sterling. And my first initiation with the town of 280 Sterling was meeting the Oakleys on some complaints with their neighbor. We have talked many a time, so I'm very familiar with it and the property owner.
So, your familiarity with the property, how does it relate to the code cases that we're here for this afternoon, which are 2022-0305 and 2022-0707?
I noticed many times that there appeared to be some possible construction done in the lower level where the garages were.
Objection, speculation.
Overruled.
As I observed, and as I would communicate with a complainant, there was evidence that there was a possible...
Objection, hearsay. He's speaking of what the
Overruled.
complainant told him. Is there not an evidence code here?
It is actually, remember, the rules of evidence at these hearings is very lax.
And what is the definition of lax? I believe hearsay would still be kept out.
No, it's actually admissible.
Okay.
It's allowed, yeah. You can go ahead and
I'll still
provide
build
evidence
the record.
otherwise. That's,
Yes.
But I mean, and again, it's the same fashion.
Conditions seemed to indicate that there was an apartment or an area built out in the right side, as looking at the property from the front, of the garage area. My complainant, who lived at 260 Sterling Avenue, contacted me, and he conferred with me about how he felt it was also built out. So that is how he was. The
Counsel?
Yes, Your Honor. I would just object again and ask why they don't have this complaint in here as in state law and even down to the ordinances here. It is applicable that if he's available, he should be here to say all these things himself.
Counsel, like I said before, I'm going to allow it. If you want to go ahead and cross-examine him afterwards, you are more than welcome to.
No
But
problem.
I'll allow it and give it the weight that it deserves.
Upon further investigation, I was able to obtain some photographs of the interior of this structure, and those seem to indicate that there was a build-out of the lower level.
Officer Stout, during the course of your investigation, let's, I'm going to ask you the following question. Did you observe work that, at the property?
No, I did not.
Okay. Did you see evidence that work had been performed on the property?
Yes, I did.
Did you subsequently have an opportunity to review the town's records to determine whether or not any building permits had been obtained for the property and the work that you observed?
Yes, I was.
And were there any permits obtained for the work that you observed and you photographed?
No, there were not.
What did you do then?
I then, after doing my investigation, I opened up a case for work without permit, ground level.
And what was,
That was,
please explain to the special magistrate the next steps.
the next steps was notification to the property owners, which we did through our normal process of posting it on the property and also sending it certified mail.
Opportunity during your investigation to make
Objection. What's the special magistrate file? What are you referring to?
the
Same-
town's files, materials that
It's
are
the same
available.
file that you were given.
Wait,
Are you gonna put it in?
what's the basis of the objection?
What he's referring to and what Mr. Stout's reading
Oh.
off of,
Okay.
as he's a witness right now?
So if we're allowed to finish our
you
examination,
can
we'll then,
proceed.
we'll then submit into the record or let, I'm
All
sorry.
right, let him proceed with the examination. I'll reserve on that one in regards to the documentation.
I'd like to know what the clerk's mentioning to the witness right now.
I'm sorry?
They're whispering off the record. I'm not sure what they're saying to the witness that's on the stand right now. Isn't this a proceeding?
It is a proceeding.
So
It is
if we
lax,
could just
like I
have
said
some,
before,
at least
the
minimal
rules-
formalities.
So the,
The rules are much more informal than they are in state and federal court.
But there are still some rules.
I understand that you're concerned about it. You can go ahead and put Ms. Schumacher call Ms. Schumacher afterwards and ask her, what did you whisper in his ear?
Or we could just put it into it, but I understand. Thank you.
All right, proceed.
what did you do then?
We, as I said, we issued the notice of violation and followed the procedures that we do when we issue our notices of violation.
Okay. This time, Madam Special Magistrate, we would enter into evidence the notice of violation that Officer Stout has previously testified was served upon the property owner.
So admitted.
I haven't seen it, Your Honor.
Sir,
Notice of violation, the one that your
Hold
client
on,
received?
hold on.
Yeah, I'm not sure which one they're referring to or which case number or any of that.
sir, when you came in the door,
With a,
I handed you the folder.
And just to let the court be aware, or the special magistrate be aware, that this was handed to me 20 minutes before the 11 a.m. start time, in which I've had multiple emails to Mr. Herron, the town attorney, requesting all documents prior to the court date or the hearing date, in which all of the emails to the town attorney have been ignored, and one even being deleted before being read.
These are all public records, and he could request staff, and he could come and inspect them at his
Correct.
convenience.
I would not contact the staff of which are your clients. That would be unethical.
wait, hold on. You're objecting to the documents that regarding the notice of violation that your client has, which would give reason for why you were hired in the first place.
Well, I was
You're
asking
complaining about not
Mr.
having
Herron
the
for all the
documents.
documents that he anticipated to use in the hearing today.
But he doesn't have to, again, that, if you wanted that, you had plenty of time to go ahead and do a police records request. There are procedures.
I just figured there was some professional courtesy, but
There is no discovery
I don't disagree
requirements.
I don't disagree that there needs to be professional courtesy, and that you could have, but again, it is not a requirement for counsel for the town to provide you with documents when you have the ability to do your own legwork and get those. It is a professional courtesy, but it is not a mandatory thing that he has to do, because being public records, you have the same ability to obtain them yourselves.
Correct, but due process also applies here.
The fact of the matter is that
The process is, you're here, right? You got notice?
Yeah.
And you're,
I did
you got
not get
right?
notice. I've asked the town for notice. I've not been provided
You're
notice.
here,
Correct.
okay. So
and you're going to be heard. I mean, you're on the podium, and I'm
That's right.
hearing you now.
Madam Clerk,
That's right.
I'm sorry.
So what
I'm
is the
sorry.
basis on the due process?
Was that? It was just posted
just
on the
make-
website. It was, yeah, I've asked Mr. Herron for notice myself. And again, those requests were denied or ignored.
But notice of what? What is the notice that you wanted Mr. Herron to give you?
Everything, down to what these violations were for. They're not specific. They just have a blanket rule on top of them. There's been no specificity as to any of this.
They're not required to go ahead and give you that much specificity. They cite the code, they put it in there a basic
they
of
don't
what
cite the
of what
code
the
here,
code
though.
requires, and it is the statute in the notice
They're
of violation.
not giving
which
us the
led for me to be
statute though,
retained.
but we'll hear that later. You'll hear that it was inadequate, but that'll
Madam
come later.
Madam Special
That
Magistrate.
is part of your argument. Let him finish his presentation. You can make your objections, but again, the hearsay is going to be admissible. The rules are lax.
But
You have the right to go
I
ahead
don't
and
think it's a
cross-examine
blanket
any
rule that
witness
it
you
should be
have.
admissible.
All right. Counsel, proceed.
Thank you. Officer Stout, the notice of hearing that you issued to the property owner, was that in conformance with your understanding of the requirements of Chapter 162 Florida statutes and the town code?
Yes, it was.
After you issued the notice of violation, the notice of violation to the property owner, did you have any chance or any opportunity to communicate with the property owner?
No, I did not. I was waiting on the property owner to contact me.
Did you reach out to them? Can you be a little bit more specific? Did you attempt to contact the property owner, and did they fail to respond to you?
They did not respond to me or reach out to me.
Okay. What happened at that point?
Well, the original hearing was scheduled for March 17th of 2022. That hearing was canceled, and they received a notice saying that the hearing had been canceled. That was sent on, in the document, that was sent on February 4th of 2022.
Did you or at your direction was notice of today's hearing sent to the property owner?
Yes, it was.
And did that notice go out in conformance with the requirements of Chapter 162 and the town code as you understand them?
Yes, it was.
Can you please tell the special magistrate what is it that your observations and the photographs that you took regarding the alleged violation?
The photographs I took show clearly that there were walls had been constructed in an area that was...
I'd have to object. I'd like to see the best evidence rule of the photographs themselves. There's no need to have the testimony of what he saw.
You have those?
Process here, I was trying to lay the appropriate foundation. If opposing counsel is willing to accept the documents into the record, then we'll here at this point submit the photographs into the record.
There was no foundation for what his observations were. We don't know what he's referring to.
Well,
That would be the due process foundation you're speaking of.
All right. He's providing you with testimony about what he saw. There are pictures. You are entitled to go ahead and see those pictures. So that's why I'm requesting the town to go ahead and provide you a copy. However, counsels for the town has properly noted that he should have been shown the document, the pictures that he's testifying to. So do we have a copy for the attorney for the property owners?
yes, we do. They've been provided.
All righty.
So which picture is he referring to?
Okay.
The pictures in section...
The witness, again, has a whole binder in front of him.
Yes.
This is
And those-
not a
hold
proper
on.
proceeding.
Hold on.
Let us finish. And maybe we can dispose of some of these issues if we were not interrupted every time we attempt to prove up the case.
I'm just trying to do it properly.
All right, stop. Why am I having to? I've yelled more today than I've yelled, I think, in my whole
There's
collection
a common
of hearings
denominator.
doing this. All right, stop. Counsel for the respondent, do you have copies of the pictures?
I don't know which ones he's referring to in this
Wait, do
question.
you have copies? My question is, do
Yes.
you have copies of the pictures? Okay, then let him continue. You can ask afterwards, make your notations regarding the statements, and you can ask him, what picture are you looking at? But if we go ahead and we have to detail every single picture that he's looking at every time he opens his mouth, we're never going to be done here with the cases. And we just don't have that type of time, okay?
That's why I
Hence
brought
why
it to
the
your
rules
attention
are-
that he's not
hence
referring
why
to
the
any
rules
pictures.
are less formal. Okay, that's the whole purpose of this. This is not the state court. This is not federal court. This is not a criminal punishment case or a wrongful death civil case. Okay,
But it is
Let
property.
him go ahead and proceed. You have the pictures. Look at the pictures. Take notations, and then you can go ahead.
That you took of the property in question that show what you believe to be is evidence of violation of the town code.
Yes, I can.
Okay. Can you please identify those for the special magistrate and opposing counsel for the record?
Yes, in the folder that you were given, Ms. Magistrate and Counsel, they are pages 23 through 25 in section 3 of the folder.
Does your folder have page numbers?
And he said 23 to 25.
I was given a folder with no page numbers.
Okay.
Okay,
You can proceed. I'm in section 3.
you see section 3, there are the 3 pictures.
Here, for the record, I am showing
I said we
opposing
can
counsel the
proceed.
specific photographs that we are going to rely upon. Are they in your file that has been provided to you?
They are.
Okay. Officer Stout, do those photographs show the downstairs area of the property in question?
Yes, they do.
And what do the photographs disclose or show?
They show to me that there's walls have been constructed.
Objection, speculation.
It is quite evident to me,
Hold on, let her
Overruled.
continue.
it's quite evident in the pictures that I can see walls and doorways that are constructed right inside the man door. And the picture that was taken at night even shows that there's electric, light, and cabinets.
In order to be able to do such type of improvements, would a building permit be required, assuming a building permit could be issued?
Objection, leading.
Overruled.
Yes, a permit would be required,
And
remodel.
this time we enter into evidence into the record, enter into the record the photographs that Officer Stout has testified to, unless there's...
So admitted.
I would object to that, Your Honor. There's not been a foundation of when these pictures were taken.
Overruled.
And in there's also another objection that these pictures are a violation of my client's expectations of privacy, as this is through the curtilage of their home.
Overruled.
Madam Special Magistrate, for the record, because opposing counsel had indicated to me that he was going to raise this issue, and I would direct the Special Magistrate as well as opposing counsel to the 2 following cases. One is United States versus Holmes, which is a federal case where the court determined that there was not an expectation of privacy with respect to curtilage for overflights of helicopters and other activity by which illegal activity was observed. And specifically to this specific issue, I would bring to the court's attention the federal case was United States versus Holmes, and it quotes Taylor, which is a U.S. Supreme Court case. The Florida companion case is Florida versus Riley. I'm sorry, that. I'm sorry. The Florida versus Riley is the U.S. Supreme Court case regarding overflights and observations and the curtilage and determining that there's no expectation of privacy to the area enclosed by a fence. Very specifically to this issue, the Florida Supreme Court in Serentopoulos versus Florida at 629 Southern 2nd, photographs taken from the adjacent property that were in plain view are acceptable and admissible into evidence.
And Your Honor, Special Magistrate, there's clear distinctions here, as Mr. Stout must have been unaware of the property lines, and he was on the homeowner's property for these pictures, as well as he's reaching through the privacy bushes that are well beyond their corner of their property.
Objection. As
Counsel,
facts
you're
and evidence.
reaching. Hold on. You're really reaching. It is very evident.
No,
that
ma'am, he was
of
reaching
the other
through the
property.
bushes.
That's fine. You can preserve your record, your record, and you can go ahead and appeal it if you want, and show the pictures to a different judge. But right now, I'm going to overrule your objection on the basis that these pictures were not even taken from your client's property itself. It was from the neighboring property. You can see the fence, that he is not over the property line.
That
There
fence
a
is not the
difference
property
known.
line. You're making an assumption, Special Magistrate.
Counsel, I can see them from the pictures. You can see the fence.
And that's not the property line. So, again, the court is making an assumption based off of no foundation and no testimony.
So is your statement that fence is not the dividing line between both properties?
That is correct.
Do you have any evidence to support that?
Special Magistrate, whether or not the fence was or was not on the property line, the expectation of privacy would have been from the fence inward.
Yep.
Incorrect. It's from the property line.
Not according to the Florida Supreme Court.
Listen, I'm gonna kill the argument right here. I'm gonna overrule the objection. I'm gonna allow it. If you don't agree with it, then appeal it. Okay? Proceed.
Well, yeah.
As of today's date, have you had any communications with the property owner regarding attempts or manner in which the property could be brought into compliance?
The only time I had any conversation was with Matt Oakley, one time when I was delivering.
Officer Stout, there are two code cases. Can you explain the process by and why there are two separate code cases?
The second case, 0707, is basically a follow-on to the first case, 0305, because we were getting into the near June 30 magistrate hearing. So we created a second case, so those citations could be addressed separately, and because they had a time frame of 30 days, and that would extend past the June 30th magistrate hearing.
So we're clear and we understand that case number 20220305, which we're testifying to right now, that was a notice of violation, giving the property owner a reasonable period to come into compliance, and when that failed, a notice of hearing and today's hearing.
Yes, well, again, there was another notice of hearing for June 30th, 2020.
Yeah, I understand. I'm just simply saying that no citations were issued in this particular case as opposed to the 2022-0707.
That's correct.
Nothing further at this time.
All right, I'm trying to. We have two cases. I think you lost me with why there's two of them.
Special Magistrate, the second one is where the city initiated a separate case with a series of citations, and as the Special Magistrate knows, is that is permitted under state law. It is a slightly different process, and there were a series of citations that were issued, and if the Special Magistrate finds that those citations were properly issued, and the facts support that case, then each citation would be validated, and the amount of those citations on the face of those citations imposed as the appropriate fine.
All right, so for purposes of the violations itself, are we just talking exactly the same violations on both of them?
Yes,
Just
ma'am.
different process of trying to bring it before the magistrate?
Precisely.
Okay.
What would the
All right, so,
different
it's,
process
so
be?
for purposes of the hearing, even though that's two separate cases, they're technically one and the same in regards to the violation that they're being cited for, correct?
Yes, ma'am.
Okay, got it. Counsel for the respondent, proceed.
Mr. Stout, have you ever been on the property of 280 Sterling Ave?
Yes,
When?
multiple times regarding some complaints that the property owners had against their neighbor.
Against the neighbor that led you to the complaint of the violations here today?
Yes, sir.
Do you know that guy personally?
Only through our, my position.
Was there any violations or findings from the complaints of the respondents today against that homeowner?
Against that homeowner, yes.
Did it stem from the complaints by the respondents?
Yes, the complaints that the Oakleys made against their neighbor were followed through. They were issued warnings. They came into compliance, and those cases were closed.
And in retaliation, that was when that homeowner...
Objection.
Can I finish the question?
Basis,
Form, characterization, you said retaliation.
I'm going to allow it. Well, please rephrase that, use the retaliation word.
So we are using evidence. Okay, so, Mr.
But otherwise,
Stout,
I'm going to allow it.
have you ever seen the inside of the home?
No, I have not. Other than the pictures.
Other than the did you take these pictures?
Yes, I did.
Even the ones at night?
Yes, I did.
And when did you take those pictures?
With a few days prior to this, to February 18th.
So when did you take those pictures?
I don't know the exact date.
You can what?
I may be able to give you the exact date.
Why
can
do you
date-
not have that prepared for today?
I did not know I'd need that today.
Now, so tell me what you see again in those pictures?
I can see walls that have been
How
built.
many walls?
Let me get two of the pictures myself. Okay, in the picture at nighttime, I can see a doorway to the left. I can see the wall that the cabinets are against. I can see lighting on a wall.
So how many walls do you see?
In that picture, I see two.
And are you aware of this home at the time that that it was all permitted work in 2018?
The ground level was not permitted.
Are you aware that Fort Myers Beach gave the permitting to Lee County for a short while of time after Hurricane Irma?
The permits that were completed for after Irma were done through the town of Fort Myers.
And then approved, well, through Lee County and still approved by Fort Myers Beach, correct?
Objection, asked and answered.
I believe that's a different answer or a different question.
Just Dan, I'll let him rephrase. I think he's trying to clarify. His question was intended to clarify. You can rephrase it because
Yeah, so Lee County was doing the permits after Hurricane Irma.
No, the town of Fort Myers Beach was doing the permits.
I'm going to sustain it. He did answer. He did state that it was Fort Myers Beach.
And so you're not aware that Lee County, you were never aware and are still not aware today that Lee County was taking permits after Hurricane Irma?
Objection.
What's the objection?
Assumes facts and evidence. There's been no proffer that Lee County, there's no one here from Lee County testifying we were accepting permits on behalf of the town.
Do you have anything on that, Counsel?
Yes, I'd asked you to take permissive judicial notice of
Okay.
the LIPA for 280 Sterling Avenue, in which it shows all of the permits that have been approved and finalized, and why we're here today. All of this was done after Hurricane Irma in 2018, and the Fort Myers Beach, they get a complaint from a neighbor 4 years later. And that's what led to these, all through a picture through the curtilage. I mean, I'll save that for argument if you would like, but I think it's very important to take permissive judicial notice of the permits issued by LIPA, by the Lee County, because they had that permission at the time after Hurricane Irma due to all of the permits coming in from the damage of that storm. And at that time,
Right.
all of the work that was done by a contractor, and it was all approved, and it was all permitted work.
Do you have those plans and the permits for that? Because I'm not agreeing or disagreeing regarding the Lee County, because I'm well aware that there was a point in time when Lee County was the entity with jurisdiction issuing some permits.
Correct.
I don't know out of the top of my head what that date was. But the question is, this is very eerily familiar to the same case we just did that we called first today regarding the upstairs and the downstairs.
Your Honor, or Special Magistrate, and that's where I would like to just disagree with you as far as the similarities of the case earlier. This case is one that there's absolutely no proof proffered by the town attorney or Bill Stout that any work was done after the permits of 2018. They have no idea that any work was being done at the time of the notice of this violation. It's all based off of a picture from the yard next door in which there's cabinets. Yes, cabinets were put in there. There's no issue and no permit required for any storage within a home on the lower level. And they have hobbies and they collect things and they put them into those cabinets. There's no living space. There's no one living down there. All of the electric and plumbing was grandfathered in, and all of that was permitted in 2013 when they bought the home. There's no other work that can be shown by the town that would put my clients in a position where they are out of compliance or did any work that was outside of a permit. Everything was contracted and permitted.
All right. Are you, as an officer of the court, have you looked at those permits and the plans that were approved for those permits?
Yeah, who was present for the walkthrough, and we had multiple phone calls and whatnot back and forth with that.
No, my question is, but just like I did with the other previous case, in order to make a determination, and again, argument of counsel is not evidence. I would have to be able to see the actual building permit, the actual building plans that gave way for those permits, for confirmation that those permits were in fact for the what is actually seen in these pictures for that habitable space downstairs.
Correct. And Special Magistrate, I'd be happy to provide that to you, but I believe you're going to have a finding that there's any possible violation here to begin with. This is their case. This is our first hearing. These violations have never even been established.
I don't know about that. I think that the town has sufficient right now to have brought the code compliance case, and it would be your
I believe
defense
that burden
to say
will switch.
you're wrong. Hold on. It would be your defense to go ahead and say, no, they're wrong because this was permitted, and here's the permit, here's the plans that gave way to the permit. So, too bad those ad.
No, Special Magistrate, I would have to disagree with you there. This is, like I said, this does go towards life, liberty, or property, and we're talking about property here, as these fines would take property away from my clients. So due process does apply. And so the town's burden here, the town's burden would be clear and convincing evidence, and then we would discuss a defense of the burden would then switch to the respondents, to the homeowners, to say that they were never out of compliance. The non-compliance needs to be established first by clear and convincing evidence.
I don't believe that is the standard upon which we operate. And the argument regarding due process, again, just like I said with the previous argument regarding due process, you got a notice of violation, you got a notice of hearing, you're here, and you're having your opportunity to be heard. Now, the town has presented evidence that there appears to be work performed without a permit.
So are you having a finding without their case being done?
Hold on. Based on the totality of the evidence that they have, they were in the right to go ahead and present that case and bring it forward. Hence the reason why the legislature has created Chapter 162 so that we have a hearing where you have that was documented by these pictures. Again, correct me if I'm wrong, but this is what I'm hearing. You seem to be representing that the work that can be seen in that lower level through the pictures that the town has put into evidence was part of the permits that were issued by Lee County after Irma. But right now, I'm all hearing is argument from council. I'm waiting for you to substantiate that with those plans or something beyond that.
Well, yeah, and
beyond your argument.
just for the record, that only came up from your questioning while it's still the town's open case, and I'm on a cross of their first witness. And again, these violations, there's been there's no way that non-compliance has been established through Bill Stout saying that he took a picture and saw a wall. There's no way that that could possibly legally be clear and convincing evidence.
Just like I said, keep saying, I'll give it the weight that it deserves. But the picture.
Correct. So are you
has been admitted.
finding these?
I can have two eyes. I can see what's there.
So you're ruling on this case during the cross-examination of the first witness?
No, I'm not. Literally what I tell you is, I got you. You got my attention. I was the first one to say, you know what? I do know that Lee County was issuing permits. I gave you that one, which is contrary to what Mr. Stout said. Now, what date was that, and was it right after Irma? I don't know. It doesn't seem like anybody here knows the exact date. So hence my question, do you have the plans that gave way for those permits, whether they were issued, the permit was issued by Lee County, or whether they were issued by the town? It doesn't matter who issued them.
Yes, Your Honor. Give me 1 second. They were not only just signed off by the Lee County, but also by FEMA. If I could just have 1 second to bring those up.
I have them all on Dropbox.
And who is this person next to you?
This is Mrs. Oakley. I apologize. This is one of the property owners.
Hi, how are you? They're actually on LIPA.
Right. But if you,
Permit numbers are on there.
yeah, would you like the Lee County permit numbers for all of them?
Well, in addition to, I have the permits right here. I'm looking at the building construction permit data, and the closest one that comes into that time frame is BLD 17-0101 for building remodel and repair. And that was in October 12th of 2017. Is that the one you're referring to?
Well, we had two different contractors. We had two different contractors. So the first contractor we let go because there was some drinking and drug selling stuff happening with his employees. So we ended up letting that contractor go. We started over with a new contractor. When we applied for these permits, you actually went to Fort Myers Beach to the town and applied for the permits. They sent the stuff up to Lee County, and like Alan Weiss is actually who worked on our permits, and we had communication with him often throughout this process. We applied for the remodel permits in May of 2017 before the storm. And we had done some of our own plans, and they, obviously spit those back to us and said, Alan said, yeah, no, thanks for playing, but no. So we hired an architect, and we worked with Kendra quite frequently throughout the process, and our architect redrew the plans, and we were going to do a major remodel on all the staircases on the house, and we changed where you entered on the house because of this neighbor that Bill has, took into warranty. This is a very harassing neighbor for us. We have several things with the deputy's
I don't want to hear
office.
about the neighbor. Keep saying
Right.
you were going right until you diverted there.
Yeah, well, it's
Going.
frustrating.
That's
I'm
irrelevant.
going to tell you.
I don't care about that.
So we applied for the permits. We were granted, before Irma going to change the, we were thinking of taking our bathroom out downstairs. It was, there was, electrical down there and plumbing already. We weren't sure what we were going to do with it, so we kind of just left it off the plans. We didn't have a ton of money. We're, just average Joes. So we, went forward. Irma hit. We had the stuff was approved to do the work, and we went through and, started working. Had the first contractor, had this big mess because of Irma. We had like 3 feet of water downstairs. Everything was destroyed. And we went back, we started over with a new contractor I think in May. By May, we had already fired this contractor, which we have ongoing proceedings with as a matter of fact. And so then we started redoing everything. But in the meantime, we had actually had rough stuff from the first contractor had been actually inspected by Lee County. They came out and did the inspections at that point physically. And then anything that happened would go to Lee County, it'd go through Alan Weiss, it'd come back down to the beach, and then they would reach out to us. And sometimes, you know, all those steps, we would get left out. So then eventually, when we finally hired the new contractor and a hurricane hit and all that stuff, I was like, you know, Kendra, there was a girl named Misty that we worked with. Do we need more permits? The outside of our house is destroyed also. And you know, what's going on with the interior? We have the plumbing, we have the electrical stuff, but you know, all the sheetrock down there is destroyed. We have to, what are we supposed to do about that? So they said, no, you don't need it. This covers all of it. So we're, okay, well, here we go. Well, then our second contractor, husband plays golf for a living. He couldn't put a piece of drywall up if you had to. But, so we went through all that. Our new contractor went, he tried to get the permits, and you can see it in the records that they have that are on the, that I got from when I went down there and tried to talk to Ellie. When this all started, before we hired an attorney. And we have reached out to the city, myself personally, to the old town manager, to Bill, to Daphne, to lots of people, and we never got a response. We wanted to know what to do to resolve, and it was all just, you did this, you did that. And we're like, no, we did this in 2018, and we have been broke ever since. Right now, what we did was we put some countertops on stuff that was already down there and some wall tile up before hurricane season because we know it floods. It's flooded 3 times. And so we're totally aware of what goes on down there and what might happen. So we finished the project. We ended up having to redo the roof. We ended up gutting the whole entire upstairs because the whole house was full of mold. We had to scrub all the air. Everything had to be closed off in the end, and the whole house had to be redone. We followed as much as we could. Our architect is actually one of the people that works for the building department for Lee County also. And yeah, his name's Kerry Jenkins. And so at the last minute, you know, the whole project was stopped or whatever, and I think it might have been you, Bill, that came out in 18 or 19 or whatever year that was now. And FEMA put a stop work order on our house for like 8 weeks. We had like shrubbery ready to go down, sod and everything else, and our fence was just being finished up, and we almost lost it.
Special Magistrate, you're on mute? Or she can't hear us?
Oh,
we can't hear you.
Jacob.
We can't hear you. Looks like they're working on it.
All right, can you hear me okay?
Yes.
Okay, looks like
So-
this thing died out.
FEMA put a stop work order on it. The whole time, Eric has been, he applied for all new siding, and we had, we found out once we started tearing the house apart that we didn't even have plywood on the outside of our house. We had no moisture barrier, so the whole house was taken down to the studs, and the roof was just to the rafters. And the downstairs, we had to, you know, it was torn apart from the first contractor still, and so we had to replace all the floor joist or whatever that are on the bottom floor to the top floor, and it was still flooded from Hurricane Irma. You know, we live on it's on very low-lying property, and we're on a canal. So every time we get a high tide and a full moon, and it rains, it's going to flood. Our lot floods. It's just how it is. So we, you know, we went through a very painstaking process to apply for all of these permits for air conditioning, for the roof, for and we did this out of pocket. And then we eventually got an SBA loan after Irma to pay for it. So that was another $250K. We wasted our money on the first contractor that we got from insurance money. And then, you know, the rest of it is out of pocket for us. And so we have been very precise in what we did down there and following the letter of, you know, this is a permit, this is what we need to do. Our second contractor, you know, tried to get these permits. And when I went to the city, when this first thing with this code came up, I was like, you know, you can't get online anymore to look at any of this stuff because I used to, you can't see any of that anymore. You don't have access to any of that anymore because when Lee County sent their stuff down to the beach, that was it. They cut the ties. And then even I've been to the, who's the councilman for the area? That's, who? No, not, I don't know, the guy that's in Estero, I forget his name. And I've contacted him, and he's like, whatever you need from Lee County to prove that you guys did what you're supposed to do, you know, well, I'll help you with that, but I don't even really know what we need, because it's so difficult to communicate. I have over hundreds of emails that I have sent to the city trying to resolve this, and I'm not getting anywhere. It's just kind of like we did this bad thing, but we didn't. We did the best that we could, and now, you know, we're having to prove that this one wall that he sees in these pictures is actually a wall that was already there. This wall that is where the cabinets are that have no countertops. That wall is, you know, something that happened between our architect and our contractor about the stability of the house and holding it up, which I will say we had, you know, we had some substantial damage from Ian. We took an 11-foot wall of water, but we didn't have any structural stuff, and, you know, so we're kind of leery to take that wall down, to be quite frank. I mean, it's all studs now.
The problem, what I'm still not seeing, and I appreciate the narrative of it, what I am seeing here is that we have a building. I'm going to tell you the permit list, which I'm sure your attorney has before them. Dating back to 2017 when Irma happened. In October, after Irma, I'm seeing a building remodel / repair, right? I see the permit. That doesn't tell me that the work that was done downstairs as that is being presented as by the town as being in violation for work without a permit, whether that be 17-0101.
Yes,
now,
ma'am.
After that permit, which was issued on 10/12/2017, I see you had an electrical permit afterwards. That was on January 1st of 2018. Then we have a plumbing permit out for January 23rd of 2018. You have a roof permit of January 26th of 2018. You have an electrical permit for in March 22nd of 2018. Another plumbing permit November 13th of 2018. And the AC permit in December 6th of 2018. All of that work happened after Irma. And again, I'm not disputing whether yes or no regarding the Irma, that Lee County was handling the permits. Not that important to my portion of
Yes,
the
ma'am.
case that we're in here today. But it is imperative that there is some documentation regarding whether the work that was done downstairs is part of that permit number, the only one that I see in that neighborhood after Irma, which is that BLD 17-0101. So there is one thing for you to have a building permit issued for remodel or repair, but without actually seeing that permit, how am I supposed to know whether that includes the downstairs work and not just the upstairs work?
Yeah, and all of that's been provided. I mean, everything here is, there's all these violations of work that's been done without a permit. There's been no work done since well before all of this. The downstairs was only back to what it was prior to Irma. The cabinets that are in the picture are not even fixtured. They're not connected. They're just, and they're not even there anymore. We're talking about a house that is now down to the studs again because of Hurricane Ian. And there's absolutely no way that the town would be able to show us anything from since then now.
All right, but I don't have anything from you
That's what I'm trying
showing
to
that other than the testimony. And the town comes with both testimony and a picture. I understand your argument, but like I keep going back to that. How am I supposed to do? How am I supposed to know by just looking, by hearing you argue that there were permits pulled after Irma, which I'm seeing them. Whoever issued them doesn't matter. I am looking at the permits. I see the permit numbers. I just don't see the actual permit or the plans that led to that permit. So without that, you don't have concrete evidence that work was part of those permits that were issued after Irma. I mean, I don't think that's that hard to follow.
Well, the thing is, again, we're in the wrong part of the case in which I was still on my cross. The only reason I was talking about these permits is because Bill Stout, in his direct testimony, stated that he's never seen any permits. Again, it just shows that he has no credibility here. He didn't even know that there was
Objection.
being done by Lee
Well,
County.
Objection.
But and again,
What's the
I
objection?
understand that. I understand that, hence what I just told you.
And-
I'm looking at the permits. I'm literally telling you, I'm looking at the permit numbers. So, like I've said many times before, I'll give it the weight that it deserves. And I literally said, I'm looking at the permit numbers. So we're past
Correct.
that.
Hold on.
But I'm not getting the,
Hold on.
For the record, my objection is that the statements of counsel are contrary to the testimony of Officer Stout. Officer Stout said in his testimony was, there are no permits for the downstairs improvements that are now finished out.
and
Again,
I
if there are,
understand that, hence.
we have
hence
asked
my-
for them and we have not been provided them
You
because,
have the
hold on.
possession of,
I think I've made my position clear in regards to the permits. I have to be able to see the plans that led to that
you're
permit.
not letting me finish. I have
Because-
one more thing about the permits that's
So
very
do you-
important. I think this is gonna be very important to hear, okay? There were permits in the possession of the town of Fort Myers Beach since Irma. There was a change of whatever computer system or programming system that they had. They existed, they no longer exist. That's all, a lot of the emails that my client has reached out to the town, and she can pull up those emails if you need to see them. We're reaching out to the town saying, why don't you guys have the record of these permits that you used to have? And it was all down to, they no longer have access,
I
and so
have
there
it.
are
I have-
permits. And that
And just so that you know, I have those emails. I do have them. So my next question is going to be, I heard something that you had an architect draw plans. So are those plans something that the homeowner has in her possession?
I do not, because everything was being stored downstairs and is now gone. So no, I do not. And the city, I know the city has these because Ellie has emailed them to me before. I'm happy to email them to you now if you'd like, or send you a Dropbox link so that you don't have
So
to
wait a
open.
second. Do you have them or you don't have them? Because first you said you don't have
I do
them.
not
and now
have
you're
them
telling
on
me
my
you have them.
person to share physically here today, no.
That'd be
But the-
fantastic, because that would solve, if we are able to see those plans that led to those permits from Lee County, then we will be able to assess regarding the permit issue regarding that. Basically, it would prove your position that this was all permitted by Lee County.
The
But
plans
it was
did
permitted.
include the electrical and the plumbing downstairs, which is the communication that we've tried to do over and over again with Bill and the city official, or the town staff, that what, you want me to apply for an electrical and a plumbing permit that's already been done and already approved in the plans and done, it was already done, it was already in the plan, so what am I applying for? That's the question I have over and over times under the same permit number, as you can find in the records from when Lee County came out, and they put the notes in the records, that the electrical and plumbing was there. Do you know that, Bill?
I'm seeing, like I said, I'm seeing the permits. I'm looking at the permit numbers, but I don't have the actual permits themselves and the plans that led to those permits. And if you have them, like I said, though, that would completely eliminate the whole argument. But if those plans do not
Madam
reflect that work
upstairs and
downstairs
downstairs.
was permitted, whether by Lee County or the town,
Yes.
and the documents were lost,
Madam Special Magistrate,
yes.
with all due respect to everyone here, the town believes it has submitted into the record sufficient competent substantial evidence to show that a permit for the downstairs work has.
And I
Excuse me, ma'am.
understand your argument.
Okay, and
But-
so
but there-
the burden now shifts to the other side to show that there
Correct.
existence of a permit.
Correct.
That cannot
And I
legally
stood-
be
and
correct.
hold
I
on,
haven't
hold
even
on.
finished my
And I-
cross-examination.
So,
Hold on, and I don't disagree, counsel. You've went ahead and you established your case, the shifting has burden to them, hence the questions are directed to them. So I'm giving the opportunity for them to go ahead and
So
present
they
their
rested
case.
their case then.
rather than having a
Hey!
ramble,
Stop.
let's finish
You
the
can't both talk at the same
cross-examination.
time. That's why I'm allowing the respondent and her counsel to go ahead, and if their argument is that those permits included that work, then they need to provide us, I want to see the actual plans to see if it was in fact part of those permits.
When you're saying that the work, what work has been established? What work was done?
Well, you're telling me that everything downstairs had been permitted, right? That the work that you're here on today,
I'm
of
saying
that
we have to
violation-
establish what work there is for there to.
Client was just that they
And that's because this
finished
is
out the downstairs,
sideways.
this downstairs
Hold on.
area as it currently exists.
Yes, it's a storage area with electrical and plumbing that's already been, that was there.
And we would
Like
respectfully.
I said, okay, stop.
Yeah.
Now, both of you, no more arguing amongst yourself. You're direct to me, okay? And end of the crossover and talking over each other and arguing, okay? Direct it to me. Again, is there a permit? Because I think I heard the homeowner say that she did have in some email a plan of some sort that would actually
we're
show
gonna
the work
email
that
to
was
you
done
right
under
now.
those permits.
We'd ask for a copy of it as well.
And you've been provided.
You guys have it, I got it from you.
Councils, I just asked you to not be cross-talking. No cross-talk.
Yeah, don't
Sorry.
talk. Go ahead. Send this. What email would you like it to, Special Magistrate?
Okay, please send it to
Yeah.
MROCHE
What's the MROCHE?
at M as in Mary,
Yep.
R as in Roger, N as in Nancy, law, LAWPA.com.
And Special Magistrate, he's still sworn in and understand, and they're going through all their documents. So MORCHE at MRNLawPA.com.
Me to do it from the computer.
Madam Clerk, can I see what you showed council?
Objection. We've not entered
Well,
that
well
into.
then, wait, what's going on here? Again, I literally just asked you guys not to be talking to each other.
I couldn't agree with you more. And council and the clerk just walked away and we're discussing what's on the laptop. I asked to see what's on that laptop.
You don't have the right to go ahead and be asking what is on that laptop, council. That's their personal business, okay? If you want to go ahead and find out, get a public records request and request it.
With the clerk during a hearing? Sorry. MORCHE
Let me know when you send it.
at MRN Law PA.
Do we still have a lot of people in the audience, non-attorneys?
I think it's just the staff.
This is the last case?
Yes.
Okay. Just wanted to make sure that nobody else was waiting.
It's sent.
It's a link. It's all the
Perfect.
documents that I have.
And Special Magistrate, this was all going to be brought out over the cross and whatnot of, and the procedure of this hearing should have been the town with a proper cross, and then they rest their case, and then a finding of the violations or the non-compliance, or compliance and no violation.
Council, we're not in state court or federal court. Like I said at the very beginning, this is intended to be an informal proceeding.
It's very informal.
And I understand that you may want to go ahead and treat it like you would in just regular court as if we were in a trial, but that's not how we do things in this type of proceedings. Sometimes I wish it was the regular rules,
Absolutely.
because it'd be a lot easier to keep control, but
A lot more professionalism. Just to clarify,
I'll check spam just in case.
morche@mrnlawpa.com.
That's correct.
Okay.
It might have gone to spam, so let me check. I'm checking spam just in case. Oh, wait. No. Was that document heavy, or was it just, I think she said there was a link, right?
It's a link to a Dropbox, and then, but with that, it'll take you, the
Why is it
first
not coming?
thing it should take you to is the plans.
Yeah. Should have come in through already then. And it's an M, like in Myrnabel. So basically my first name, initial, and Rocher. Come on. Let's see. Check here just. Still don't have it. Spam, junk. Still not coming through. Oh, no, that's not it either. Come on. And then comes trash. Nope. Just try to resend it again, just to make sure. Because it should have come, especially a link like that, should have come through before. Already by now. And I use Dropbox, so it's not the Dropbox issue. Could you check your outbox to make sure that it did actually leave?
Yeah, it's in my outbox. Let me just tell you the email
Yeah.
address, make sure I have it correct.
Okay.
I have morche@mrnlawpa.com from Trish Oakley at Gmail.
Okay. Yeah, even more reason. Should have come through.
I emailed the link to the Dropbox, but I can try sending it directly through Dropbox.
Did it get out of the outbox this time?
Yes.
Okay. Or should be here then any second. Come on. So. That works. Yeah, try that too. And it's yeah, even if it didn't have the first part connected, I would be getting it anyways.
Special Magistrate, that bounced back. M-O-R-C-H-E.
No, it's M-R, last name. So M,
There we
last
go.
name,
Yeah, I've read it back
R-O.
every time. Oh, man. Yeah, every time I've
It
said
should've-
it. O-R. I have it written down here. Oh, that makes sense. It'll come right to you right now.
Surprise, it still should have come through, but yeah, I sent it again.
As M-R-O. I got it.
Oh, I think I got it, hold on. All right, Mr. Herring, were you provided with the document, with this?
Well, yeah, it all stemmed, that my client got this from the town, so.
Okay.
But
So
I-
we have-
No, I have not received it, Madam Special Magistrate. So
All right,
if he
I'll forward
wishes
it
to
to you.
use it here today, I would appreciate if you provide me with a copy as well.
Well, it's public
Oh,
record.
Mr. Herring, I'll send it to you.
If he wishes to use it here today, I'd appreciate if you provide me with a
Alright.
copy.
Don't delete this email.
I got it, I'll send it to you now.
Perfect.
And for purpose of the record, the one I got was the one with the actual, the plans, not the Dropbox. Okay. And the,
We were never able to get a copy of the CO from the city. They didn't have it. LE claimed that it was, Lee County had it in their documents somewhere. And we had lost it with, with, everything that was going on with the mold and everything in our house and all the construction. We actually lived somewhere else for several months after Irma. We weren't even in the house. So it went through and I applied for it and then, then we hired an architect, hired a contractor, fired a contractor, hired another contractor. He tried to get the rest of the permits that we needed. Like myself, he was told by the city that we had everything we needed because the electrical and plumbing in it. Then the sheetrock that we were gonna do downstairs was repair and replace. And, so we went on, he went on, and then FEMA stepped in and we had to, go back to Lee County and through the city, and that lasted for like 8 weeks or something, and my contractor and the architect couldn't get anything done, and actually Alan Weiss and our architect their little cubicles are not that far from each other. And so they were abreast of everything that was happening with us, and then when FEMA finally released it, it was because of flood vents downstairs and what was going on with all of that. And so that we actually had flood vents in, we had put the flood vents in during the process. And so FEMA stamped off on it and we moved on. And
Before, let me ask the question, sorry, before you keep going. The FEMA issue, around what time was it? Do you remember?
it's on the one with the red that's signed by Alan Weiss at the bottom.
That's those revisions at the bottom, Special Magistrate.
No, I'm looking at, that's exactly
Like
why I
what
asked,
file?
and sealed on February 13th of 2019 by an engineer. That's for the roofing. You've got the foundational ones for the deck.
I still don't have copies of any of the other work permits because I don't have access to them. These are the only ones that Ellie gave me pertaining to this particular permit for the BLG one. Nobody has access to those anymore. You have to go through the city because it's on a different software program. So I'm assuming she gave me everything. I don't know. I looked at her straight in the face and I said, do you think this is everything or do you think there's some stuff lost in Lee County? And she said, I don't know. So, this is the best I can do. This is the best I can prove what happened besides the, 3,000 pictures I took with metadate stamps on them of this work being done, of the downstairs and upstairs at the same time, during this process of being inspected over and over again. Obviously, they're going to tear the walls downstairs out and replace them because they were putting in plumbing and new electrical outlets in the whole entire house. So yes, of course, we did sheetrock work downstairs. We already had a bathroom and stuff down there before we ever started doing this. There was a bathroom downstairs when we bought the house. We've never had a stove down there. We've never rented the house. We've never put it up for rent. We are a single family dwelling and that's it. So if something's wrong, we have wanted to fix it the whole time, but we don't know what to fix. We have asked several times to several people, what code are we in violation? Because we had plumbing and electrical, yes, we tore the walls out. We had to put in new plugs. We put in new light fixtures. It's not that we, and then we had 3 feet of water. So when we first started the process, it was before the storm hit. The storm hit, and we had, obviously more damage. If you go through all these files in here, you'll see where Alan sent a letter, Alan Weiss from Lee County, asking for an updated thing where our second siding on the outside of our house, because it was basically gone. And I never even saw that letter. My contractor never saw it, but he wanted formal drawings of that, and we never even we never even knew about it. And so, there was a lot of stuff that happened after Irma. It was no different than what's going on right now with permits and trying to get work done. And, we did the best that we could. My husband and I truly feel that we are not deserving of, however much these fines have rang up to now, and that we wanted to do the right thing. We've always tried to do the right thing. We just had these guys out to, look at we had to get our electrical fixed after Ian to get the box redid so FPL would hook us up and all of that. And we had the electrical, his name's Freddie, he came inside downstairs, he looked at everything. I had some questions for him about, what is this, what is that, what do you think we should do? And he said, yeah, you guys need to get a second ground wire, do this and do that. He goes, I'm gonna fail you this time and then we'll come back. And this has just been, maybe October, November, whenever it was that FPL was able to get on our street, we started working on that. So it's not, we're more than happy to, abide by whatever we're supposed to do. We're not, we're hoping that our tax dollars are paying for the help of the city to make sure our stuff is in code and it's the way it's supposed to be. That's what we want. But, being just like you did this, you did that, we didn't do that.
I think, okay, so let's go ahead and I'm looking at the plans and I'm seeing that as suspected, the plans that were submitted back in 2017 was intended to be a garage, and there is a notation in this section where, and I'm going to refer specifically, in sheet A1, which is going to be the very first plan you have that you sent me. There's two, as you can see, there's to the right hand we have the existing first floor plan, and on that same document to the I'm sorry, to the left, we have the first floor plan. To the right-hand side of that document, we have the existing ground floor plan. And that existing ground floor plan says that that is intended to be a garage. There appears to be a small storage area in the very back, a small storage room that shows a toilet and a sink.
Yes.
That gets access through a little door, right? And that little door for where the toilet and sink was is immediately adjacent to the entryway into that what's supposed to be garage space, right? Now, on top of where the toilet and the sink is, it says existing to be removed.
Right, we started off as a remodel. In May is when we originally did the plans. Those are revised
Okay.
plans on their, we started as, we weren't even really didn't want to do the downstairs, but we knew that the electrical and the plumbing throughout the whole house needed to be done because it was in such poor shape. The house was like a tent when we bought it. And so we took that on with our architect saying, yeah, I guess we need to put it in the plans. We were unsure of what we were going to do with the downstairs at that point. It was not in our plans to do the downstairs at all at that point. We just wanted to make the upstairs livable, a little more comfortable for us, and get the electrical and the plumbing, right. But then after the storm hit, and it was different. And so it wasn't that we wanted to do that. It was never our intention to do the downstairs. We didn't have a bathroom that we used. The most we used it for was to hook up a water hose, and we had a little fake tub in there. We hooked up a hose to this little shower head thing that was still there from when we bought it, and we would wash our dogs in there. That's what we used it for. It was a tub to wash the dogs in after we got off the beach. And
All right, but here's the problem. The plans that gave way, just like the other one, the plans that I have before me, which appear to be the ones that would have given way to that permit. Again, don't care whether it was the county or the town, whoever issued the permits, based it off these set of plans. These set of plans show that that lower level is intended to be a garage with a small storage space in the back.
Correct, and that's all it is. That's all it's ever been. That's what Steve Strader saw. That was a town employee came and saw it. It was all just storage. There's nothing.
But it doesn't, but here's the thing. If you look at the plans, the door that would have been open for him to be able to see inside the property would be the one, of course, that on the exterior wall. There's only one down there, right? There's only one door to the exterior wall.
The whole area is enclosed.
Yeah, say that again, Special Magistrate. I think I'll be able to walk you through it.
Okay.
Say that again.
So, in the plan, the portion of the plan
Correct.
that shows the ground floor, if we look at the very first one,
Yes.
sheet
You see
1A.
the two swivels for the doors?
Okay, so we have the one in the ground floor.
Correct.
I don't care about the first floor. I'm
Correct.
talking
Yeah,
about the ground floor.
Yeah.
Okay. Okay, we agree in agreement so far.
Oh, you're coming from the back of the house where the stairs are showing?
Where the stairs are showing, there's one entryway to that ground floor to get inside.
Yep, that
And
was a
it's
garage door.
intended to be a garage, right?
Correct.
Yeah, that garage
Okay, we're in
door.
agreement with that. And now, once you enter through that door from the outside into the ground floor, immediately there's another door for that storage area, right?
So, yeah, they're all on the right-hand side of the plans that we're looking at. There's only two doors
Correct.
right there.
I don't
two
care.
swivel
I don't
doors.
care about the left-hand side because the left-hand side is the first
No,
floor.
I'm talking about the
only
right-hand
focused-
side. I'm talking about the ground floor plan, the outline. I'm
Yes,
saying the
the
right-hand
ground
side
floor.
of that. There's the door. That's the door that the building official Stout was peeking through the bushes. That's the door he took the pictures through. You can
Correct,
see the other
correct.
door. That's the storage space. But
Correct.
what's kind of irrelevant is you can have pretty much anything you want in your garage, and there's no building code that you can't have storage in your garage, even though it's
And
not.
I don't disagree. I'm not
Yes,
disagreeing with
but
you.
and I just want to let you know that this has all been explained. He can say he doesn't know about this. I've had multiple conversations about all of this with the town attorney. I mean, I walked into that, and he even told me that this is our second hearing. We've never had a hearing before. This is all just I don't know why.
Can I finish
Yeah,
what I was saying?
go
Because
ahead.
you're jumping in without me finishing
Go ahead. Yes,
where
ma'am.
I'm getting to.
Yes,
Because I
ma'am.
have questions. So you get into the ground floor, and it says clearly that it's intended to be a garage. And I agree with you, you can store in habitable space.
Correct.
And I appreciate the homeowner saying it's never been a habitable space, we
never
don't intend
has,
to do
yeah,
it out,
no
that's great.
intent,
Okay,
correct.
fantastic. Now, after you get into the space, into the garage area, there's that little storage area, right?
Yes.
That has a toilet and a sink that says existing to be removed.
And
And as we scroll down through the rest of the sheets, that sink and that toilet disappears because it is expected to be removed, right? The permit that was issued was
Special
issued based on
magistrate, if
these
you go
plans.
down,
Hold on.
it says
Let me
to
finish.
remain.
Let me finish. In the rest of the plans, the toilet and the sink are not there, and it clearly states on that first sheet that the existing is to be removed, right on top of the toilet and that sink. Now, the permit that was issued was based on these plans that I'm looking at, right? We're all in agreement with that.
Yes.
And according to these set of, according to these set of plans that we're looking, the permit that was issued contemplating that that sink and that toilet were going to be removed, because there's no other permit, there's nowhere in these plans that shows that a new toilet and sink
You
were
have
going to
to-
be placed or anything like that, right?
Wait, yeah, Special Magistrate, scroll down to the third page there, the revised ones. That language is changed to
What
remain rather than to remove, where you read it in the same
Which sheet?
same spot. If we're
Which sheet?
looking, hold on one second.
It's on the bottom right hand.
Oh, I'm sorry, fifth, where it's, again, the proposed ground floor electrical plan. That's one of the revised plans in which that whole room was to remain.
Yeah, but that doesn't mean the toilet and the sink were to remain. And by the way, the one you're referencing to is the electrical plan. That wouldn't have any bearing regarding the architectural
Correct, but it
layout
was
of
the
plan.
revised plans. And
So,
No, and I'm not accusing you of doing that. I'm just pointing out that the plan that was approved, which led to the issuance of the permit, on sheet A1 says existing to be removed right on top of that toilet and the sink, meaning that there was not supposed to be any plumbing fixtures there, right?
And
Now,
again,
your-
we've
council-
gotten all to this not through any proof of the town. So I just want to make that for the record. I just want to put that out there. Absolutely none of this has been proposed by
Well,
the town
again,
attorney
like
or
I'm
the
saying,
building
the
official.
burden-
But
the
no,
burden-
I understand. I don't
burden
agree that
shifted
it's
to
shifted,
you.
but I do understand where you're at now.
Correct, and I appreciate you having the plans ready because it makes a big difference, right? And again, we're here for compliance, and it does appear that there might have been some confusion, and I'll just put that there, in regards to what can be done, can or can't be done. So we're gonna resolve this issue today, okay?
That sounds good.
So now,
Ma'am.
all right.
Hold on, let her go.
So we have here in these plans that what was supposed to happen was that this room, according to these plans that I had before me, was for that ground floor to be a garage
it was a garage.
with that small room in the back without any plumbing fixtures. There is electrical approved, okay? So that section, there is electrical approved, and they seem to be running, I think these are the columns or the rafters. I think it looks like they're running through the
floor,
ceiling portion.
the floor of the second,
For the upstairs, probably
right,
likely
so
for the
that means
upstairs, yeah.
to bring the sewer lines out, you have to hit that toilet down there because it all goes through that. And then it comes out, so there's a toilet downstairs. I never even knew it was about the flood vents until I went to Lee County after we got this code violation thing. So I never saw these revised plans, but, overall, though, it's my understanding, and I may be wrong because I can't seem to get an answer to it, is we did the revisions, we did repair and replace of what we thought was okay by what we were told by the City Hall folks, and we, we did the electrical and the plumbing plan, and we were really, our architect put what on there, he was not, there's actually 2 doors missing off of that plan also that were downstairs that are not drawn on there because we weren't gonna do the downstairs. We just weren't. It got lost in the wash somewhere, and I don't know how to fix it, and I'm trying to fix it, but it's not happening. And so the revised plans, I never saw those until just recently, and So there, yeah, there's no toilet on there, there's no anything. But when we fixed the downstairs after the flood, after this permit was issued, we did the best we could. And if, you know, we had to tear all the sheetrock out to put the electrical down there and to put the plumbing. Everything comes through the floor, you know, from the upstairs. So it's
And
not like
I
we
understand that,
did.
and that I can see that from the electrical plans. I mean, I'm not seeing any plumbing plans, but I'm seeing the electrical plans. Yeah, they're running through the ceilings.
But you can
exactly
see
for that
the-
reason, so that they can feed upstairs,
Right, but you can see the plumbing was taken out on the LIPA.org website. There are plumbing inspections that have been done. There's been 2 different plumbers that have been on it as subcontractors with the contractor. So,
But the fact that there's plumbing permits doesn't tell me anything, because you did also work upstairs, which included plumbing.
right,
Hence,
because,
the town's position is that somehow your plumbing for upstairs magically appeared without running the plumbing system up into it.
Right.
The problem is
Then-
plumbing. The problem is plumbing servicing that ground floor. Those are 2 different things.
okay, so yes, you're correct. We did not apply to put a new toilet in downstairs.
Correct.
did
And
not-
the plans as
We
the-
did not
the
approve
permit-
any plans to be submitted to anyone by Alan Weiss, our architect, or anyone that took that toilet out. Or the water heater that was downstairs in the utility room, and the washer and dryer connection, and the shower head, and the sink that was all down there. That's not on there because we weren't gonna work with that.
Well, hold that thought, because I think that I saw something that you might actually do have it in the plans. Hold on.
The original
'Cause
plan.
yeah, you have it in your, that portion of it, regarding the water heater.
And special
The
magistrate,
washer dryer in the 2nd floor, it is referenced in what would be the approved electrical plans. And if they're approving the outlets for that washer and dryer, by virtue, they would have had to approve the plumbing system for that washer and dryer, right? So that I agree with. It looks like the toilet and the sink, no. But in terms of the electrical necessary and the plumbing necessary for that washer and dryer, and potentially even a water heater, is referenced in the plans that would have become part of your permit. So you're good there.
special magistrate, I think I can expedite this as far as the toilets and everything. I just have a few questions for my client, if you'd like to hear them. It's very relevant to what we're at, where we're at right now. So, Ms. Oakley, do you have a toilet in that storage room right now? We can expedite all of this. Is there a sink in that room right now?
No,
Is there any plumbing or anything else connected in that room right now?
no,
All right.
All right.
Is your downstairs empty right now?
yes, and there's
Is
no
your-
electrical down there either.
And is your downstairs empty as far as, is there anything else in the garage space of your ground level floor?
There is some paintings that are very rare art that I'd love to keep, but they have mold on them, so I'm probably gonna have to give in and throw them away eventually.
Okay.
And my husband's master's chair.
Are there any structures or fixtures downstairs at this time right now? All right.
But the question is that at this time, remember that he took pictures, and right now, because of Ian, I am sure that you removed everything because of the mold.
And do you
So again,
plan-
my point is to go, because right now, because there was potentially work without permits before, but a lot of it might have been removed, we might already be close to compliance by accident, unfortunate accident of the storm, that might get us faster. But she wants to know what she can and what she has to fix or not fix, so we want to go ahead and get to the bottom of it, okay?
Correct.
So I'm going to go back now to the pictures, now that we've established that the permits that were issued by whatever entity after Irma related for that bottom floor to be a garage with a storage, with a small room for storage in the back, which appears to have included electrical and plumbing for a washer and dryer and potentially a water heater. Okay, so we got that first. Is everybody here now on the same page that that permit after Irma in 2018 was intended for that to be a garage with a small storage space in the back with a washer, dryer, and potentially water heater?
No, ma'am.
No. Actually,
We're not in
no,
agreement.
the drawing is wrong, so whoever did that revised thing and wrote on there, that
That was
yeah.
actually going in your favor.
We're happy to show you the MLS pictures of when we bought it, of what was down
And
there.
that doesn't tell me anything, because I
Right.
mean, every day houses, properties are sold with horrible code violations that, again, you bought it with the violation, you bought it with it.
Special magistrate, could I proffer something to the court? Could I proffer something to the hearing? Yeah, hold on one second, Ms. Oakley. Special magistrate, would you be interested in some kind of court offer or anything? As far as 60 days, we'll have a compliance review in person. I'll be present, the town can be present, anyone but Bill Stout, and we will have a inspection for compliance in conformity with these plans that you have in front of you right now, and no fines.
I mean, if you want to go ahead and do a consent judgment to that extent, to go ahead and come into compliance within 2 months, then I don't think the town will be disagreeing with that.
I mean, they're in compliance right now.
Special magistrate, and Miss, I apologize for.
Let me hear from the
I want to go
town
where you're
on
headed.
that suggestion.
I want to go where you're headed. I think that given the circumstances, that it would be appropriate for the if the property owner is agreeable, the town will dismiss the second case, 2022-07-07, which is the one that has all of the citations accrued.
No.
Hold on, Mr. Stout. Is that the one that has the citations or not?
There are citations
Okay.
associated with 305.
Is it 305? I'm sorry, is 305 the one that has the citations and the notice of violation?
There's 305 and 707 both have citations.
Okay. So, with that said, that there are citations, I thank you. That we enter an order, it's agreeable, that the property was in violation, is currently in compliance, subject to the verification, that the Oakleys pay a one-time, because the violation's 90 days. And we will dismiss case 2022-07-07 and then work with them toward an explanation as to what is now allowable in the downstairs area as they move forward with repairing their home as a result of the damage caused by Hurricane Ian.
All right, I'm not going to comment on it because I want to leave counsel for the respondent to go ahead and respond to that.
Yeah, Special Magistrate, we're willing to, they're in compliance right now. There's still argument that they were never out of compliance. The town has never seen anything that would tell them they're out of compliance with the plans that we just went through. So if there's a $0 fine today, we will be in compliance. We could do the 60 days, we could do the 90 days. But this is just a money grab at this point for the town. They could have went about this a lot better. I mean, we have, like, the efforts by the homeowners here have been astounding as far as how many
I'm not that, you're way
but
outside
that's
of the boundaries
all relevant
here.
to them trying to
So this is, I wanted to give you the
reconcile this.
opportunity to respond, and I think the right way to do it is almost, I want to say split the baby, but I think there's valid arguments on both sides on how to proceed. So the first thing that like I said, when I was talking about the plans as they were permitted, there might have been a violation regarding work done without a permit. I still don't have it at 100% that is possible. However, when it comes before me, my orders are always go ahead and get it in compliance. And it is possible, I don't know that yet either, it is possible that due to the Hurricane Ian, that there has been accidental compliance because a lot of the stuff was damaged and is going to have to get removed. Obviously, now that's going to be another step because of the work that has to be done to get the property outside of the permitted plans that have been presented, meaning the toilet was supposed to have been removed, the sink was supposed to have been removed, and there be that back room used as a place where the washer and dryer is kept, and a garage on the outside portion and the larger portion of the area. That would have been corrected anyways by when Ian came and did the damage. So my inclination right now is to continue the hearing until the next one and provide the opportunity for the town to go in to make an assessment as to what is there. And if there is a violation, let's say, for example, they go in there and they find, you know what, this wasn't part of the permits, this should have not been there, should have never been there, that there is going to be a time for you guys to be able to either get a permit to get it complied with, or remove it if it's just not possible. But it seems to me, based on the evidence that I have right now, that that property was, the lower portion of the property was permitted to be a garage and a storage in the back with a washer and dryer, and anything outside of that would be unpermitted work.
But it
Okay?
wouldn't have been work, it would have been
But-
lack thereof. It was already there.
But-
So that's what I'm
It
saying.
doesn't matter whether it was already there or not. She bought it with it. If it was in violation back then, she bought it with it. If it was put after the fact because she didn't know that it wasn't permitted, again, she eats it. But my point is that right now, based on the evidence I have, I don't have enough to know if, by virtue of Hurricane Ian, this property has already come into compliance. We don't even know about it. So the only way to go ahead and get that assessment is to have the town enter that lower level and see if there are things in that lower level that are outside of what was permitted back in 2017, 2018 after Irma. And if they're way to that permit, then those would be the ones that are subject to the violation. But it sounds like perhaps a portion or the entirety of it is already gone because of Ian. Either way, I think the way to go ahead and come to resolution to this is to allow the city to go ahead and inspect, see if there are in fact violations, and if so, what precisely those violations are. Because coming here right now, if I base it off the evidence that I have, and I'm actually, this is more towards going towards the homeowner, trying to give the benefit of the doubt. But based on what I'm seeing right now, there appears to have been some sort of kitchen in the works or something when the picture was taken. That might not be the condition the property is in now. And as such, I cannot enter a ruling finding that there's a violation when I don't know if the property is in the same condition as when that property was taken, right?
Correct. And
So there could be compliance just by accident, like I keep saying.
Again, Special Magistrate, I think you're jumping the gun and assuming that those cabinets were in non-compliance. There's nothing.
I'm not assuming it. I'm not assuming anything. I'm just
we
saying
have
I can
many
I can
efforts.
see cabinets.
Yeah, and I've reached out to the attorneys multiple times with no responses to have an inspection.
Well, I'm going to order it here today.
Yeah,
I'm
as
gonna
long as
order
it's
it here
not Bill
today.
Stout, we are more than welcome to have an inspection.
I don't know that you have the authority to go ahead and dictate who goes
Well,
in
then
or
they
who
can
inspects it or
obtain
not.
the
You can make the
warrant.
request.
They can
but
obtain the inspection warrant that I've let them know of because we just won't agree to Bill Stout. I feel like he's conducted some wrongdoings in this matter
Well,
and continues to do so, and wasn't even aware of the permits in Lee County, which is also
Right.
very relevant to all of this.
Well, I am going to tell you that if I enter my order and it's not complied with, again, you can make the request, but I don't think you have the ability to go ahead and dictate who goes in or who doesn't. If I order the inspection to happen, somebody from the town will be there. I don't care who it is. I don't care who it is. I can't dictate who they send or who they don't send. But if the inspection doesn't happen for whatever reason, then I'm going to proceed with the evidence that I have. And you're right, I'm going to go with the pictures of what I'm seeing in the interior. And then that means that at the time the violation was, the notice of violation was issued, it wasn't, the violation was in fact there, and since we
What's
haven't,
the
the town hasn't
violation in
been
those
able,
pictures?
since the town hasn't been able to enter, that you're out of compliance, and because they can't confirm that it's no longer there, okay?
But what's in those pictures that are out of compliance? That's what we have not established.
The citation is actually specific regarding what those, the violations are. It's specific to the lower level. It tells you that there's electrical work, that there is plumbing work, and that there is interior finishes done into, on the countertop into that lower level that are outside of the permit. It's pretty darn specific. They don't have to tell you that outlet is out of place, that thing is out of, they don't have to give you the nitty-gritty details of everything.
What
All
I'm
they have to
asking
tell you
is, what evidence today shows that there was ground level build out, electric structure, plumbing?
The pictures.
What pictures? From the pictures Bill Stout took?
Counsel, I'm not going to have this discussion here with you.
You just said that
You
the
can
countertops
either-
were not part of the
Counsel,
non-compliance.
I am done. I'm done, okay? I'm done. I'm
Jesus.
entering the order for the town to be entered at ground floor to inspect within 30 days. Failure to do so will be an admission that there is work without a permit, and I will proceed accordingly, okay? That's
right.
it, because I'm trying to bend over backwards here, trying to get this thing there. Because if they go in and there is no violation, then your case gets dismissed, right? There's no violation, there's compliance, we're done. But if they go in there and they find that there is a violation, then it needs to come into compliance. But we don't know that until we enter the property, right?
Well, you're
Okay,
saying we.
so my order right now is that the case is going to continue with a directive for the property owner to allow the city to enter the property to inspect it within 30 days, okay? 30 days,
I'm
that's
not
it.
arguing that. I'm arguing that I just would like the order to include anyone but Bill Stout, as he testified today. that
I
he
am
doesn't even know
not
what he's
doing that.
looking
I
for.
already told you 3 times.
Okay.
I am not doing, I'm
No
not
problem.
dictating who the town sends.
Then we
okay?
are,
You can make the request, and had you not nicely, maybe they would do it. I don't know if they're going to, but I'm
Well,
not going
it's
to
been
dictate
ignored
who
for-
goes or not.
Madam Special Magistrate, if I can address that issue and only that issue. And I've had this conversation with Mr. Melchior.
Yeah, after multiple-
Excuse me, sir.
I am not going
may-
to entertain.
he may disagree.
I am not. Stop. I am not going to entertain argument as to who goes or who doesn't
Well,
go. My order is 30 days for the town to go ahead and enter. I don't care how it happens.
Well,
I
my
don't
point,
care
and-
who
and-
makes
and
these mistakes,
I want
okay?
to, I want to state for the record that state law in our code specifies the inspection and the reinspection must be done by the code enforcement officer. And the code enforcement officer of record in this case is Mr. Stout.
Okay.
So in order for us to comply with state law, it has to be Mr. Stout. Now, we can go with a bunch of other people, but Mr. Stout has to be part of the reinspection, period. under
And
state
counsel,
law.
I'm sure you're welcome to attend. It is your client's property. If you are that concerned, be present when the inspection takes place. It has to be coordinated, right?
Well, the
So
thing is,
everybody's
they
gonna be on
also
the same
have,
page.
they have the.
Well, listen, if
But
you go
I
ahead
understand
and-
rules don't
and
apply
this-
here.
Like I
What's
said,
that?
I
30 days
am not
compliance, and the case will be
going
dismissed.
to dictate who enters the property. All I'm ordering is for the inspection to occur, and if it doesn't happen for whatever reason, then I'm going to go ahead and proceed entering my order accordingly. That's it.
And-
End of story.
and as you
the rest
stated-
of it, whether you're there or not there, who goes in or who doesn't, and who goes from the top, don't care for purposes of my order, okay?
Yeah, and your
Doesn't.
order is going to say that if there's compliance, both cases get dismissed. Is that what you stated earlier?
No, what I'm saying is we're going to make the assessment as to what is already there, okay? And then based on what is there, I'll go ahead and issue my ruling. Because right now, I'm not going to go ahead and comment on something that I have not seen.
But
Understood?
I'm asking you. You said earlier.
So, I am done. I'm over. Case closed. That's my order. Proceed accordingly. If you have any further
Goodness.
argument from there, because I think it's pretty simple, allow the property to go in. Based on what the findings are after that inspection, okay? Then I'll make my ruling. I am not going to make my ruling right now without knowing what's there.
But-
Okay? Understood. Understood.
Yeah.
Thank you.
All right. Have a nice day.
Thank you.
Thank you, Madam Magistrate. There are no further cases before that staff has at this point.
All right, that's uncontested.
Yeah, the remaining 2 items on the agenda have been brought into compliance, and staff is withdrawing those at this point in time.
Okay, I'm sorry, the rest of them have been complied or continued. All righty, great. Thank you all. I guess I'll see you in a
June?
couple weeks.
Thank you.
Thank you.
Thank you.
Thank you.
Y'all have a good day.